Said at least in what the late Ailsa Wilson, as Jim McCulloch used to call her, but anyway.
Okay, welcome back everyone. We're on day 12 of the inquiry. Could everyone silence phones and other devices, please? Before we continue with Mr McIntosh's cross-examination, we've been handed a draft timetable by the appellants, and thanks very much to those on that side for preparing that. That looks very helpful. Some people might not have had a chance really to look at it in detail, but are there any comments on that just now? Mr Thompson.
Thanks. So the only thing that occurs to me is whether it might be an idea to have a break of a day between finishing session 2 and the hearing session, just to give people a chance to gather their thoughts before the hearing session. So that might be on the Wednesday, and that would give a buffer day in any event in case there's an overrun. But just a thought.
That sounds sensible, although I know that others have time constraints or availability issues subsequent to that. Can we see what others say, and if that seems as if it would work? It seems like a sensible suggestion. Yeah. Mr Mackay.
Yes, good morning, sirs. I would tend to agree with that suggestion. The only thing I would confirm is that in the week commencing 8th October, in order to minimise the impact on holiday commitments, Dr Middleton will be called before Stephen Robb.
Okay, thanks for that. Ms Coburn.
Yes, thank you, sir. That's no problem. If HAS's case was to finish early, Mr Lowry could probably manage Tuesday afternoon if that would help. As I say, it's the mornings with which Mr Lowry has his difficulties because of his teaching.
Okay, perfect. Thanks.
I was able to speak to Dr Batas last night, and for him it works better if he's the first witness on the Monday morning so that he can return that afternoon or early evening to London to teach on the Tuesday. But other than that, it seems a rational schedule.
Okay. Would you have any objection to that, Mr Thompson? That's Dr Batas being run before your two witnesses there.
No, sir, no problem.
Perfect. Mr Innes.
Yes, so far the first couple of days of the week commencing the 15th October look absolutely fine. I'm currently awaiting Dr Conlon's availability for the Friday, which I had, even prior to seeing this timetable, anticipated might be the appropriate time. I do fear that the Thursday-Friday looks a bit like a Northern Rail timetable, and I wonder if it is realistic to get through all those witnesses within those 2 days, and wonder whether it is likely that if Mrs Nimmo and others on the Wednesday were likely to take a full day, and whether that might afford an opportunity for effectively that part of the appellant's economic case to start on Wednesday afternoon, which would seem to make the timetable probably more manageable. And as I just say, I think that Thursday and Friday looks a little busy, and I just wonder whether I wouldn't anticipate that the evidence of those 3 witnesses would take a whole day, unless Mr Steele knows something that we don't. But that seems to be a light day and too much put into the Thursday-Friday.
Although Mr Thompson has just suggested a break of a day somewhere around about then, presumably.
I think he's suggesting it the next week after the Monday the 22nd. I think he was looking for a day between Monday the 22nd and the hearing, suggesting it went to the Wednesday.
Okay.
But as Dr Conlon flies off, I think I do need to ensure that he's in that week, and I know he's got an engagement on the Thursday, so I'm just checking the Friday, and I just await to hear from him. But I think that's my only comment on the timetable, is that I think we might not make the full use of Wednesday, and that seems to be quite important in that week, and I would have thought that we could at least get or at least 1 or 2 of the appellant's economic witnesses perhaps dealt with on Wednesday afternoon.
Okay, thanks for that. Ms Nimmo.
I know I can talk, but I can't imagine we would use up Much of Wednesday.
Well, you need to wait and see what questions you're asked.
So can I just assist, because I've looked at this table and reflected on it, and if we look at the days of the 10th, 11th and 12th, I think that better progress will be made than that requiring 3 days. And I do wonder whether Ms Nimmo, Ms MacDonald and Mr Harrison could also be taken during these 3 days as well. I think that is realistic. That would then mean that the economic session could be fixed to start on Wednesday the 17th. And frankly, that would be quite important for us to know when the economic session is starting, because we have got witnesses from down south who need to make the necessary arrangements to be here. And I think it's entirely realistic to suggest Wednesday the 18th to commence the economic session. And if that could be fixed for that, that might assist Mr Innes, Dr Conlon, and it would certainly assist our various witnesses, if that is agreeable to you, sir.
So everything in inquiry session 2 essentially would move back a day, leaving us Monday the 22nd for a clear day, and then the hearing session on Tuesday the 23rd.
Save for this, I think Dr Batos, for other reasons, which I can't now remember, has to be on the 22nd, unless he can be the previous week. But I think there's a reason he cannot be there.
It was simply because he's got to make arrangements in his university timetable. I was hoping for a fixed slot for him. And the idea, and I got the impression that fixing into the Thursday or Friday actually quite difficult, because we didn't know how we were going to get on, and we seemed to be really good at underestimating. And the idea of having him call at 10 a.m. on Monday morning, he could then be, as it were, arrive on the Sunday night and be out of town, back down to Greenwich in good time to teach on Tuesday, and that just is control. And because his topic is relatively self-contained, then I didn't anticipate it really causing great difficulty. Yes, I could go back to him and suggest he comes on a Friday, but he would have to then hang around. And given the sob stories he's telling me about university meetings, that might receive lack of enthusiasm, is what I'm possibly saying.
So I'm perfectly happy if Dr Batas is accommodated at a particular time, even if it's in the midst of our case. I don't think much turns on it, no disrespect to Dr Batas, but I don't think it is critical what time he's on. If he needs a fixed time at Thursday at 10 o'clock or Friday, so be it.
Could you check with Dr Batas and see whether he's able to make an appearance on the Thursday or Friday, and in return for that we would fix a time for him?
Certainly. I know that he's intending to speak to Mr Wilkinson this afternoon once the appellant's case is closed and Mr Wilkinson's returned to his office, so I'm sure Mr Wilkinson can deal with that.
Perfect. Okay, so if that works, we would then not sit on Monday the 22nd and then have the hearing session on the Tuesday.
So can I just, from our perspective, just be certain Historic Scotland do not start until Monday at 10 a.m, and that would be with Dr Middleton? And secondly, are we agreeing that the economic session will commence on Wednesday the 17th? Because if that's so, we'll send that information to our relevant witnesses who can book flights and hotels and the like.
That sounds reasonable to me, and of course much of this will be in your control over the next week or so.
None of it's in my control, as always, sir. It's to do with the witnesses, but yeah.
Okay. Yeah, just Mr Owen's reminding me that we need to get in touch with Mr Harrison to let him know when he's likely to appear. Are we thinking that Ms Nimmo, Ms MacDonald and Mr Harrison are moving back a day or even further?
I'm suggesting so that they could easily be accommodated during the 3 days, 10th, 11th, 12th of October.
Okay.
In which order, it doesn't matter to me, but it may well matter to them.
Okay, perfect. Thanks for that. That's okay with you, Ms Nimmo, is it?
Yes, I would imagine that would be fine.
Perfect. Great. Okay, thanks for that. Any other issues that we need to discuss just now?
Yes, sir. Only the question of timing and hours of sitting. As I said at the outset, of course, I have in front of me now 20 cross-examinations And if we're continuing to sit 9:30 till 5 days a week, then frankly, both for me and the relevant witnesses, that's quite a challenge, I have to say. The standard court day is 10 till 4, and the civil courts are 4 days a week, and there's a very good reason for that, because it's to do with human endurance, bluntly, and ability to concentrate and the like. So I don't make any motion to you as to the hours of sitting. I simply say that all of that is to be borne in mind, because, as I say, 9 to 5, or 9:30 to 5, with a 40-minute lunch at 5 days a week really is, and the quality, certainly the quality of my cross-examination, if there is any quality in the first place, will deteriorate. And secondly, I suspect the answers from witnesses, as we saw with Mr. Wright, will deteriorate, requiring a constant break. So I would ask simply your indulgence and perhaps your ruling about that matter.
Yes. Can you bear with us just for a second? Okay, Mr. Owen and I would be happy with a 10 o'clock start and an hour from lunch, dependent on reasonable progress being made, and if we feel that the timetable is slipping, again, we would reconsider that.
I'm entirely in your hands, sir.
Okay, so let's say from now on a 10 o'clock start in the morning with an hour from lunch or thereabouts. And just finally, on the question of the timetable, we've made some adjustment to that just now. Could that be updated for us? And if someone could undertake to email that to Mrs. Kerr in our office, she can get that uploaded to the case website. Perfect. Thanks very much for that. Mr. McIntosh. Sorry, Mr. Thompson.
While we're having a break to discuss things anyway, I wondered if I might just raise one matter. We're about to start the Council's case, and it's the question of whether you would wish the precognitions to be read or an abbreviated form read. And I know that's dependent on your view on progress. My witnesses are sort of preparing on an either-or basis, but perhaps at some stage you could give me an indication which you'd prefer.
Well, I think the way that Mr. Steele has been taking that over the last week or so has worked quite well. That is to choose parts of the precognition to be read out so that there's a reasonable flavour given, especially for those who may not have read precognitions and so on.
I'm grateful, thank you, sir.
So just in that event, if we're discussing the Council's case, which is obviously about to start, a practical question which may affect the length of break. Do you wish the witness table moved across? And if so, does that mean all the documents will move across? We have been asked to assist the Council's witnesses and no doubt other witnesses with supply of documents, and we're very, very happy to do that. Mr. Gellertley is sitting there and can assist with that, no difficulty. But what is your preference? Because we'll need a little. If you want to move it across, we need to rejig the room, etc. Or are you happy with it?
Yeah, I'm happy with it as it is. I prefer not to move it across. There's more room there for documents, and we're happy if the table was to be turned a little or something like that to accommodate eye contact with witnesses and so on, unless anyone feels strongly to the contrary.
No, that seems extremely sensible. It seems a terrible waste to move the papers, and as the appellants are happy to help, I'm very grateful.
Perfect. Everyone else happy with that? Good. Okay. Mr. McIntosh.
Thank you, sir. Mr. Mappin, sorry to have interrupted our flow last night.
Good morning.
I want to just return to the topic of public access, which I think you address in your inquiry report at 1.652 and 166, and that's on page 17 of the report, and you make your points about why you disagree with the views of others about public access. And I simply wanted to check a few things with you. Firstly, you do accept that there's a difference in the public access between the two schemes, in that Scheme 1, as has been others have explained in detail, it has a lift from the Regent Road entrance and appears to therefore have access to both terraces below the colonnades. but Scheme 2 doesn't seem to have any access other than straight off the street to the eastern terrace below the eastern colonnade. And Mr. Gibb spoke a little bit about the idea it might be used for markets. Would you accept there is a difference in tenor of access?
Yes, there is a difference between the two.
The other thing is that, just in general terms, whilst I do appreciate the site is currently locked, so that is a given for what I'm about to say, you do accept that by building on more of the site, less of the site is even theoretically available public access because, well, there's 2 hotel wings in it. That's something that has to be borne in mind as another factor, along with the other ones you've listed.
Well, as you say, relative to the current situation, there would be a greater degree of public access, but if those buildings across open areas, theoretically, they're then taken up, yes.
Thank you. Let's move on to the 2009 procurement exercise, and I don't want to go this into any great detail, so we can probably do this without reference to documents. You've explained very fairly that you weren't involved at the time it took place.
That's correct.
But you understand, you would agree that it was some form of EU law procurement exercise involved an advert in the OJET?
Yes, that's my understanding.
And we can, if it's interesting, no doubt the reporters can read the advertisement and see what the factors that were to be considered, and they include both design and financials as well.
Yes.
So, would you accept this? It's a slightly complicated assertion, so I'll take it slowly. Would you accept the fact that the owner of a site has to sign some form of commercial agreement with a developer involving a lease with various heads of terms and consideration is irrelevant to the basic position of whether planning permission should be granted?
Yes, I think in the situation where it's private ownership, that's very much the case. I think where it's in public ownership, and I think there's a statement in a document from the council that the issue of planning risk was part of the selection process. It was considered.
Well, we can deal with that at submissions, I'm sure. But there is one area which you very fairly brought out in answers to Mr. Thompson's questions, that the economic benefit, as you see it, of this scheme is a factor you say should encourage grant of consent.
The wider package of benefits, which would include economic benefits, yes.
Yes, indeed. And just whilst we're here, so we get them clearly in our mind, it's the overall economic effect. It's something to do with training, staff resources, how staff are what they call associates, how they're trained and supported, and the cultural package. All those three are all part of this overall, in a sense, benefits that you see.
On the economic side, there are wider benefits in terms of bringing the building back into use, public realm upgrades, addressing the current challenges of antisocial behaviour. So there's a wider package of benefits over and above economic.
But the economic side, you accept that one of the arguments being made on behalf of those instructing me is that some or all of those economic benefits turn on whether they actually come to pass and the likelihood or otherwise of the particular operator actually turning up and doing what they say they will do.
Yes, that's correct, and certainly, just from my own understanding, that was a question I needed to understand, and there is a long-term agreement in place between Rosewood and the developers.
Well, that's what I wanted to address. So let's turn to the question of Rosewood and their role. Now, Mr. Steele assured me, I think the day before yesterday, that you were the person to ask. So, in your inquiry report at paragraph 79, you have set out a statement. It is the appellant's case that the Rosewood Hotel will advance Edinburgh's reputation as a world city and be of national importance to Scotland's economy. And that's the heart of your position, isn't it?
Yes, that's one of the key factors.
And you've given evidence yesterday of your meetings with the Rosewood, and we have 2 letters available from Rosewood, and they would be, well, first one, CD 336. Could we perhaps look at that, please? And this is a letter bearing to be from Mr. Aurora, I hope I pronounced his name correctly, who is the president of Rosewood Hotels, addressed to David Leslie, and it's in respect of Scheme 1, isn't it?
That's correct.
And the first sentence is extremely clear, that Rosewood Hotels and Resorts is pleased to be appointed by Duddington House Properties and Urbanist Hotels to operate an ultra-luxury hotel at the former Royal High School in Edinburgh. And we can read the rest, but the last sentence of that paragraph struck me just in passing as a little bit of an oversell, that Rosewood Edinburgh will be a place for which all Scots will be genuinely proud, and which they will view as their retreat, their local eatery and their guest house. You don't take the view that all 5.25 million of us are going to view this as our local eatery, do you?
No, that's not my view.
No, Mr. Aurora is probably quite a good salesman, so I've read it. How many covers are there to be in the restaurant, by the way?
I'm not sure. Sorry, I don't know the answer to that.
Okay, right. Now, you read... I've read this first paragraph of the rest of this letter, and indeed what Mr. Aurora said to the Development Management Subcommittee, as the idea that there is some form of agreement, or there was some form of agreement between Duddington House Properties and Urbanist Hotels and Rosewood, under which Rosewood would operate the hotel almost under some form of contract. Is that, in very broad terms, I don't want to get into commercial secrecy matters, is that broadly how it works?
Yes, I'm not privy to the commercial details of it, but that's I've been briefed that that's a long-term management agreement. Yes. And
this is between the developers and Rosewood Hotels,
as far as I understand it. Yes.
Okay. So let's go on to APP 51, which is, of course, the second letter, and that's dated the 2nd of August, and it's addressed to Mr. Hare.
I have that, yes.
And this letter starts slightly differently with a confirmation of commitment of Rosewood to the creation of a Rosewood property at the site of the former Royal High School, and then similar sort of assertions and I'm sure truly believed and meant and intended and honest statements of Rosewood's wonderful business, as Mr. Steele was explaining to us yesterday.
Yes. Yes.
Now, we can't ask Mr. Aurora about his intentions because he's not a witness, is he?
That's correct.
Now, it was something that struck me that was probably interesting to see a little bit more about how this all works, and therefore I read the developer statement from Scheme 2 with interest. Could you turn to CD 201, page 3, please? So this is the developer statement. Now, just to be clear, I got the impression from the way it was laid out and the introduction, this was actually drafted by... well, it's not drafted by you, is it? It's not your document, this document?
It is not.
No, okay. But at page 3, we have in the penultimate paragraph a statement, DHP and UH, I'm assuming that's Urbanist Hotels, have confirmed to CE's senior officers that co-investors Oak Tree Capital Management remain fully committed to the project, as do Rosewood Hotels. And we've seen some press reports that haven't been contradicted, that Rosewood, Oak Tree Capital Management are somehow involved in this project.
That's my understanding, yes.
And so this would be an American private equity company that reports on its website that its strategy combines traditional private equity and distress for control activities, investing at any level of the capital structure and seeking to equity positions result in substantial influence, control or ownership. Do you know about Oak Tree's objectives as a business?
Sorry, what was the document you're referring to there?
I wasn't. I just went and read their website. What do you know about Oak Tree's business model and what they're trying to do?
I'm not familiar with that, I'm afraid, no.
Okay. Now, Professor Murray came and gave us evidence about his professional views on the design, and in his precognition, we discovered that it said in his precognition, perhaps I should get it on the screen in front of me so I get this exactly right. It's in the folder for him. He reports that he was instructed by a company he reported called Carlton something. Let me just look it up. Carlton Hill Hotel. This is at paragraph 1.2 of his precognition. Do you remember that moment when Mr. Thompson asked him about that?
Yes, I remember that.
So, for some reason, Professor Murray seemed to think that there was an entity called the now appellant's Carlton Hill Hotel. So what do you know about Carlton Hill Hotel?
It's my understanding is that it's a vehicle that's a joint venture vehicle between the appellants Dunningston House and Urbanist Hotels, and for administrative purposes, it's the party that would have instructed Mr. Murray.
So this would be it's a Scottish Limited Liability Partnership, registered number SL16191, isn't it?
I don't know that firsthand, but I'm sure that's right.
And it has a charge over the entire share capital of Dunningston House Properties, doesn't it? Registered on the 26th of March 2014.
I don't know that. Sorry.
And I obviously was intrigued to see the involvement of Oak Tree Capital, and so. Are you aware of how Oak Tree Capital are connected to Carlton Hill Hotel LP?
No, I'm not.
And so, can you confirm whether 97% of Carlton Hill Hotel LP capital is contributed by a Luxembourg company called OCMS Luxembourg Edinburgh Apart Hotel, SARL?
I'm not aware.
So this is fascinating indeed. But it's quite obvious that Mr Mappin doesn't know these questions. It's equally obvious that none of these documents are before the inquiry. It's equally obvious that Mr Macintosh has spent a little bit of time online overnight and he's now quoting from information that he's got, which we have not seen, Mr Mappin's not aware of and is not before the inquiry, sir. It's really not very fair.
Could we perhaps go to CD 186, which is the planning report you produced for Scheme 2?
I would invite a ruling on this, sir, as to whether you think this is helpful or not, or whether this is purely a fishing exercise.
I was going to move on, actually.
Yes, I gathered that you were moving on.
Yes,
given
absolutely.
that Mr Steele's asked for a ruling, I think he's right.
Okay.
And you are moving on.
I am moving on, yes.
So can I intervene at this point and say that actually I believe this information to be of fundamental relevance to you. We're going to hear in the economic case all sorts of statements about who's got what in a manner that's confidential. And I think the appellants do owe this inquiry an explanation of the structures involved and who's involved. It seems to me that it was put in the planning statement, and I think he's going on to, my friend's going to go on and look at that, as I understand the next question. But I do think it is beholden on the appellants to give some explanation of this, and it does have a bare relevance in terms of looking at the structures that are referenced in a lot of the economic papers. So I think a ruling now on this matter may cause difficulties down the line insofar as we seek to understand what is proposed in the various economic structures that have been put before this inquiry by the appellants. So I just raise that caveat now about making any blanket rulings about this particular matter until you've heard that evidence,
So
because I think it might bear upon it.
Could I suggest that you indulge me? I won't go to any unlodged documents for a moment, and then perhaps you could then make a ruling once I've gone to 2 more lodged documents, or 3 more lodged documents, and then I'd be more than happy for you to make a ruling on this subject.
That wasn't a blanket ruling, Mr Innes. My concern is all of these references to unlodged documents, and there's a limit to what we can take from that. So let's see where we go. If we're going to lodged documents, great, and then we may need to reconsider depending on where you take us, Mr Mike.
Of course, I'll go straight to
Mr Steele.
If I may, if this is seriously going to be a line that is being taken without lodged documents, there are 2 points arising. One is clearly Mr Mappin is not the relevant witness, but if you think this would be helpful, sir, we can consider leading an accountant or financial advisor or something of that ilk. This would be highly unusual and, in a planning context, difficult to understand why it might be necessary. But if you would find that helpful, sir, because this is purely fishing with this witness who clearly doesn't know about it. But if this is really, if there's a point in all of this, which I don't think features in the statements of case or the precognitions lodged by Mr McIntosh, then we can consider the position, if you would wish that, sir.
Yes. I'm nervous about where we're going with this. I'm not sure yet whether this is information that we need to know for the questions and tests that are before us, but let's see where we go.
I will be able to take you to relevance within my inquiry statement that raise these issues, but I think I should, fairly to Mr Steele's concerns, go directly to a lodged document, which is the planning report for Scheme 2, which is CD 186.
Sorry, what was that reference again, please?
CD 186, sir. And particularly its appendix A1, which is electronic page 46. It's a letter from Pinsent Masons addressed to Mr Mappin, who would have received it sometime by post after the 9th of February 2017, and therefore I thought it was probably appropriate to ask Mr Mappin about the letter he received. Now, Mr Mappin, while you just read it, perhaps I'd like you to read it before I ask you questions. It's perhaps just worth remembering. You'll recollect that those instructing me have raised as an issue whether the Scottish ministers can rely on the assertions made that Rosewood will do X or Y or Z, and that has been part of our case since the comments to the appeal statement for and I'll take, if necessary, to the relevant paragraphs of the final inquiry statement. But within this letter, which bears to be from a substantial firm of solicitors, it reports, I might just read it out.
Sorry, Mr McIntosh, CD 186 is the planning statement.
It is. And
where in the statement?
Page 86 electronically, sir.
Thank
Numerical
you.
Page, probably 43. It's not numbered. The previous page is 42.
And the next page is 43. It's in between.
Yes, exactly, Mr Steele. It's between 42 and 43 because they're cover sheets, I would imagine, from a Word document. Now, this letter from a partner at Pinsent Masons reads, Dear Gary, proposed development of former Royal High School, Edinburgh. We refer to the missives between the City of Edinburgh Council, CEC, and Duddingston House Properties Limited, dated March 2014, as subsequently varied in June 2014 and December 2014, and then assigned to Carlton Hill Hotel Limited Partnership, CHHH, with the consent of CEC with the effect from 20th of May 2015. As far as we are aware, the missives remain in effect and are binding upon CEC and CHH, and in terms of Clause 3, CHH shall remain entitled to submit a new planning application in respect to the development as contemplated in terms of the missives. And 2, the ultimate long-stop date for purification of the suspensive conditions in the missives is 31st March 2021, subject to permitted extensions in accordance with the terms of the missives. Now, if I remember correctly from your planning report, the purpose of you attaching this was to explain, in a sense, why you were entitled to lodge a new application and how the suspensive conditions ran into the future. And there was a certain amount of public comment about this at the time.
Yes, that's correct.
The questions I want to ask, and bearing in mind that those instructing me are challenging whether the Scottish ministers and the reporters can rely upon the assertions made about Rosewood's likely activities, and you tell me there is a contract between the developers and Rosewood. The question I would like to know the answer to is, if this letter is, as I understand it, doesn't it appear to suggest that the organisation that controls the missives, and therefore the site, is Carlton Hill Hotel Limited Partnership? Now, if you don't know, I'll deal with it in submissions, but what's your understanding of that?
Well, I don't have any first-hand knowledge of the parties to the missives, other than the summary in that letter.
I can deal with it in submission, so if you don't know any more than there, that's fine, we can move on. But all I've taken from it is what it says. So I wanted to look at your planning statement for Scheme 2, which is CD 201. It's a CD 201 at CD 186, sorry, the planning statement for Scheme 2. And if you could turn to the beginning of that, round about page 1.
I've got that, yes, thank you.
Thank you. Now, you've written this document and you've explained in the first paragraph who the applicants are. And if you need a defined term in the third line of the first paragraph, and you report what happened to the previous application. And then in the second paragraph, 1.2, you've written Duddingston House Properties, in conjunction with their partners and co-investors Urbanist Group, continue to pursue their vision and desire to restore this unique building to prominence within the city. You see that? And the next sentence you begin, the developers have a long-term agreement with property owner CEC.
Yeah, I see that, yes.
Are the developers in that sentence the applicants or Carlton Hotel Hill LLP?
My understanding is that Duddingston House Properties and Urbanist Hotels have a joint venture vehicle, Carlton Hill Hotel LP.
No, you said that, but the reason I asked this, and I don't want to, in a sense, ambush you, because it did seem odd. I looked at the earlier one, which is CD 40, and that's your earlier planning statement for Scheme 1. And there seems to be a difference in the way you phrase this particular paragraph. This is 1.2 of CD 40. Now, again, can you take a moment, please, to read that paragraph? Do you see how in the 1.2 again, the first sentence refers to Duddingston House Properties in conjunction with their partners and co-investors Urbanist Group, had a vision and desire to restore this unique building to prominence, and they have secured funding and attracted a luxury hotel operator. And what I noticed, and again, it might be something me being very paranoid, is that in the second document, you've been seemingly careful to refer to the developers and not the applicants. And what I want to be sure is that, can you tell me anything about whether the appellants actually control the site? Because if they can't control the site, they can't control Rosewood. And if they can't control Rosewood, the Scottish ministers can't rely on Rosewood. And that's why I'm asking the questions.
So I wonder if that question could be put again. It quite confused me.
Certainly, Mr. Steele. I'll put it again. I'm asking you, because you're the planning consultant, you've written these two planning statements and you've enclosed a letter from Pinsent Masons, and you've been very careful to refer to the developers having an agreement with Rosewood, not the appellants, not Duddingston House Properties or Urbanist. Whether you can tell me whether it is the appellants or some other entity, perhaps Carlton Hill Hotel LP, who control the site and therefore can enter into an agreement with an operator, the operator who is said to be Rosewood, whose, in effect, covenant we are challenging.
I certainly wasn't making as sophisticated a point by not using the same terminology in Statement 2. So I'm loath to use the phrase in simple terms, but insofar as I understood the planning discussion, the applicants, now the appellants, Duddingston House and Urbanist, have a number of their own commercial arrangements, but my understanding is that when I'm referring to them as the applicants and the appellants, that's in the same terminology as Carlton Hill Hotel LP, who, my understanding, have the agreement with the council. So, I mean, my understanding is that's effectively one and the same.
Right. Now, you have been the planning consultant with the appellants since 2014, and I think you've attended the pre-examination meetings for both schemes and in both the Development Management Committee schemes.
Yes, I have.
And you will recollect that at both Development Management Committee, well, the first one, a lot of representatives of Duddingston House Properties, Rosewood and Urbanist spoke at length and with enthusiasm to the committee.
Yes.
And I now can't remember which of Mr. Orr or Mr. Hare spoke at the second one, but one of them spoke at the second one, as did you.
That's right, Mr. Orr at the second one.
Now, I'm asking you all these questions, and Mr. Steele is not entirely unreasonably asking himself the question of whether you're the right person to ask the questions of. But rather like was asked of Professor Taverner yesterday, were you aware of any discussions in your team about whether, or why can't I ask the questions of Mr. Hare and Mr. Orr? Because presumably they'll tell me anything I need to know that's relevant to the planning question.
Well, so the simple answer is because they're not witnesses. I've already volunteered so that if you think it's material to go into this fascinating accountancy forensic analysis, then we'll lead the necessary accountant or financial analyst, if you think that's helpful, sir.
So
I don't yet know whether that would be helpful.
right, well, this is why I get to tell you why I raised it. So when the one of the arguments within the inquiry, the response to the appeal statement from the appellants, and in the outline and final inquiry statements for those instructing me, has been that Scottish ministers can't rely, or should not rely, is the best way of putting it, on the assertions made that Rosewood will do X, Y, or Z, because Rosewood isn't. We don't know the relationship between Rosewood and the appellants. And so part of that was because we knew, from looking at the planning statement, that the title had been transferred to some other entity. Now, we, of course, didn't know, and one normally doesn't need to know, the financial arrangements between that entity and the appellants, because, of course, just like with the music school, you can apply for planning permission even if you don't control the site. That's a given. So it only matters, I would like to say in submissions, it only matters if the Scottish ministers or you are going to have to assess whether you can rely on Rosewood. And you'll recollect, for example, that there have been references to a rather glossy document about the art strategy from Rosewood. And I'm sure there will be material in the second session that relates to how Rosewood intend to run the hotel and the staffing numbers and things like that. And it struck us that it's therefore incumbent upon the appellants to explain. And that's why we raised it in our inquiry statement, to explain the connection. Because most planning issues I accept, and most issues, sirs, you'll deal with, this never happens because it's not on planning issues only. But we're bringing in an economic justification in broad terms, as I discussed with Mr. Mappin, and quite fairly, there are other economic reasons to do with public realm for which this is not relevant to. Where conditioning them in terms of planning conditions is difficult, and we'll discuss that in the hearing session. But if we don't know who all these people are, you and ultimately Scottish ministers are left in a position. Now, we know from the developer statement from Scheme 2 there's a company called Oak Tree Capital. I know, because I can look in public registers, about how that's connected to a company they have in the Cayman Islands, but that ultimately is not for me to say. It's not for me to prove who the appellants are.
It's really unfair to do that. These documents are not before the inquiry. And my learned friend is simply trying to suggest offshore activities of a nature that are entirely irrelevant, and it's quite improper to do that given the documentation before this inquiry. Quite unreasonable.
And so the only point I'm trying to suggest is that I had expected somebody who, in a sense, controls the appellants, not these professionals who have been engaged, to come along and explain what's going on. Mr. Aurora would have been the best, even though he doesn't control the appellants, because we could then have asked him a few questions. You could or could not have been satisfied, and that's why it's an issue. Now,
Sir, Mr. Aurora is not here. The responsibility for which witnesses we lead are mine, and that's an end of the matter. He's not a witness.
And I think I've asked all the questions I need to ask on this topic, but I wanted to explain why I've done it, so that Mr. Steele has the opportunity, were he to wish to do so, to lead additional witnesses.
Bear with me just a second. I mean, Okay, we note that you're moving on. Just to give people a bit of an indication of where our thoughts are on this at the moment, we gather from the Council's precognitions and particularly Miss Parks, I think it was, that the Council takes the view, and I hope I don't get this wrong, I'm sure Mr Thompson will tell me in due course if I have got this wrong, but the Council's view was that if planning permissions to be given for a hotel, there wouldn't be any control through the planning system as to the type of hotel or the operator of the hotel. So my feeling, our feeling at the minute, is that this may have limited relevance to the question before us, because ultimately we can take into account what's said about Rosewood, and we've been referred to those documents and so on, but the Council's view, and it might ultimately be our view, is that there would be no control through planning conditions as to the nature of the operator. So we think at the minute that this may have limited relevance to the questions before us.
So can I just say, in fairness, my submission will be that there is control in relation to Rosewood, the operator, and that material weight should be placed on that. That will be my submission in due course, just to give fair notice about that matter through a variety of means.
Clearly that's something we will need to discuss at the hearing session on conditions on the legal agreement then.
Moving on, simply observe this. I didn't want to get to the hearing session and suddenly start launching into submissions about this topic without even raising it. And I've been grateful for the opportunity to ventilate it. I do entirely appreciate that the choice of witnesses is Mr. Steele's. But ultimately, he has a case he has to lead, and to a certain extent, it has to respond to what's being played against it. I'm proposing to move on, and I'll do so to the Newtown and Broughton Community Council and Scheme 1. And Mr. Mappin, have you read Mr. Price's precognition as the planning convener of the Community Council? And so you appreciate that there's a certain amount of umbrage taken, I think, about communication with the statutory consultee in respect of Scheme 1, and you're aware of that?
Yes, I do recall that. Would you like me to look at the precognition?
Yes, I think that's probably a good idea.
Sorry, bear with me.
I'm just going to take a moment to close down lots of documents that we're not going to refer to for a bit. So in the precognition, we will obviously hear from Mr. Price, but I think it's only fair to put this to you. Now, you worked with Mr. Sorrell, but you, of course, aren't Mr. Sorrell.
That's correct.
But at the time that Scheme 1 was being processed, you were joint planning consultant for the scheme.
That's correct.
So, I think I have to put this to you, even though, because I don't know what joint means in this context, but there's a certain amount of cross-responsibility going on here, isn't there?
Yes, at the time of the first application, I was a sole practitioner. Mr. Sorrell was working alongside me.
So in paragraph 9 onwards, I'm not going to read it out because, of course, we will hear from Mr. Price in due course, but to sum it up, in essence, in January 2015, the Community Council explained that they were contacted by the appellants, a site visit was arranged, there was a public exhibition, and they wrote a letter on the 1st of April to expressing their views, and then they ended up objecting to the scheme in the autumn, and that there seemed to be a view that they hadn't engaged. And indeed, we can see that in a... and the letter, I don't think we need to go to it now, but the letter they sent in April is EW9, just for completeness. And once they sent their objection letter in, we see at CD338 an email dated 16th November from Mr. Sorrell to the Council. It's not got an addressee, but it's described as response re Newtown and Broughton Community Council comments, and it says it's 16th November 2015 in its text. And I've always assumed it was sent to the council, but I absolutely can't be sure. Do you recognise this document?
So 338, did you say, Mr. McIntosh?
338, and it's got at the top. It's got 5 lines in bold text. Former Royal High School, Regent Road, Edinburgh, and then there's half a page of text with no signature, and over the page is an Appendix 1. Is that looking like your one?
It does, yes. I'm not sure why they doesn't have any more detail around if it was an email, but
well,
I'll
I
take
did
it
wonder
as it
that
is.
too, but it seems to fit into the timeline, and one can see that because if we just look at the first 2 paragraphs, it says at the beginning the applicants are pleased to make contact with the Community Council and to show them around the site and buildings at the time of the exhibition at the start of 2015. Repeated invitations were made to NTBCC to continue the dialogue, offering a presentation, and then it makes reference to an email stream. And then it says, however, these approaches were not accepted and no replies have been received from the NTBCC since April. The appellants therefore wish the comments in the second paragraph of the letter to be put into context. And let's look at that letter. This is the objection letter from the Community Council, which can be found in the inquiry documents for the coalition. And it is... my screen has gone quiet suddenly. It is EW9. So that's the letter from April. And then other document you'll need EW8 as well whilst you're there. And then you'll need EW11, which is the Community Council's objection to the scheme. Now, if we look at EW11, that is dated 16th of October 2015, so that's within the consultation period. And the second paragraph, I must mean the one at the very bottom of the first page, we are disappointed that the comments NTBCC submitted to developers as part of the PAN process consistent with the Edinburgh Court have not led to a continued dialogue. And those comments, EW9, which is a letter dated the 1st of April, making some, I think, unwelcome comments in shorthand. And they were sent by a cover letter, which is EW8, to, I don't know who Deirdre at Duddington House is, but perhaps, Deirdre Nicholl, perhaps, on the 1st of April. And you'll see from the second paragraph, we would be happy to discuss the plans development further, but we believe this would be best once the contents of the attached representation have been considered by the development team. So that's 1st of April. And in CD 338, we have this email stream I mentioned, and if you look at the email stream in Appendix 1 to CD 338, perhaps start at the end and work upwards. Last letter, as it were, is dated email to Mr. Moat, who was then the chairman of the Community Council, on the 7th of January 2015. And if you just move up through the other letters and stop at the last one before 1st of April, we see that is an email, actually an email of 1st of April, the top of a page, 1 April, 2251 from Richard Price. And that, you see that, and that's the, looks like it's the same text as EW8.
I see that, yes.
And then, so I was sort of expecting to see further emails from Ms. Nichols to the Community Council asking for meetings that were ignored, but the next email is the 6th of November 2015. There's nothing in between.
I can see that, yes.
There doesn't seem to have been an email, this email thread is supposed to illustrate the attempts made to contact the Community Council between 1st of April and the scheme being lodged. There didn't seem to have been any. Now, this...
I can't see them in this email trail, no.
Now, of course, without wishing to go open the whole thing of who the witnesses are again, because I know what Mr. Steele has rightly said, we can't ask Ms. Nichols, but we have to ask you, because you're the planning consultant.
Okay, yes.
And you know that the Community Council is a statutory consultee and was required to be consulted.
Yes.
So it would appear that the Community Council provided a response in the form of EW9, heard nothing back, even though it wanted to hear back, and lodged an objection, and then was complained about. And that doesn't seem very fair to me, and I wonder if you care to comment.
Well, I can't give you a comment on where those communications are that Deirdre Nichols refers to. My understanding was that there was contact with the Community Council. I mean, they were obviously aware of the proposals, submitted an objection letter.
Yes, but you produced, well, I think Mr. Sorrell produced, to be fair to you, the first pre-application consultation report, which is CD03. Now, I've read, it's from Sorrell Associates, and I do appreciate that you're not necessarily the author, but you were the joint planning consultant.
Yes.
So it may be that, in a sense, Mr. Sorrell's responsible for this, and therefore I apologise, but I've read this document, and it doesn't report to the Council the views of the Community Council in EW9. Why is that?
This again is fascinating, but I wonder how helpful this is to you. We could take up a lot of time with this, and as I understand it, Mr. Mappin was not directly involved at that stage. It may be he's got a comment, but it's a question of whether you think this is a productive use of time, sir.
So, sorry, Mr. Steele. Mr. Mappin, when were you instructed?
In 2014, around April 2014.
Were you the joint planning consultant when this report was produced on the 3rd September 2015?
Yes.
Now, I don't want to take any more time on this, but I've read through these documents and I can't find a reference to the Community Council's response. I don't want to take time now. It may be that if you find it, you can tell Mr. Steele and he can put it in his submissions, but I don't find it there. And I want to draw an inference from that later on, and I don't want to be unfair and not give you a chance. As the only planning consultant I get to talk to. So could you look into that later and perhaps tell the inquiry through Mr. Steele?
Yes, I will do.
Thank you. Let's move on to the process of change from Scheme 1 to Scheme 2. Now, this is a section addressed in your inquiry report at 1.34. It's to do with the transition, and I just want to reconcile what you're saying, and I'm not sure there's necessarily a difference, but I want to just reconcile what you're saying about the process of changing the schemes with what Mr. Wright and Mr. Gibb were saying. I recollect that Mr. Wright's evidence was that in January 2016, I think soon after the unfortunate death of Mr. Hoskins, was asked to lead a review of some sort of the project, and that the first workshop he led was on the 3rd of February 2016.
Yes, that's correct.
And then the second workshop, this is from his inquiry report at 4.26, 27 and 28, was on the 15th of February, and the third workshop was on the third and final workshop, the 7th of March 2016.
That sounds correct, yes.
So it would appear that these workshops which took place involving the Council and HES, they're not internal, I understand that. Or were these internal workshops?
Though these were the workshops involving the Council and HES and the appellants.
So you've explained that there was this process where this exercise happened, and then the appellants and their own advisors reached a conclusion about what to do about reacting to Scheme 1. Now, what I wanted to simply ask you is this: when was the decision made to, in a sense, to go ahead with what now became Scheme 2, as opposed to think about it, which is what I'm assuming is happening in the workshops?
After the conclusion of the workshops, there were then further internal discussions, and at some point thereafter, there was a decision made to proceed with the scheme that was subsequently submitted for the revised applications, under the revised applications.
Given that you were the planning consultant, I just need to press you. You may not remember, but can you remember when that was?
I would have to check, but I recall it would have been around May or June of that year.
Thank you. Now, what I wanted to do now was to move on to what I think is quite difficult to get right. So I quite understand if Mr. Steele corrects me before you answer this question. My recollection of Professor Murray's evidence about the differences and acceptability of the two schemes was that he saw both schemes as, in his eyes, broadly positive, but he saw Scheme 1 as preferable to Scheme 2. Is that your recollection?
Yes, that's correct.
Similarly, my recollection is Mr. Wright and Mr. Maskell, again, saw both schemes as positive, but saw Scheme 2 as more preferable to Scheme 1. And again, is that your recollection?
Yes, that's correct.
Now, as a planning consultant, who is effectively, in one sense, I put it colloquially, telling the planning officers where they went wrong, and in a sense, advising on planning judgment, which of those approaches do you prefer?
I've pursued, obviously, both applications as a planning consultant. The issues are very broad and complex here, and I understand the position of the different witnesses from their different perspectives. And both have planning merit, and the decision has to be taken by those making that final decision.
But you're not going to pick between the two?
I don't think I can, no.
Okay. I didn't think it was likely, but I'm going to ask. Let's look at the Block 10 development brief briefly at CD 479. Now, I suspect you're quite familiar with this document, probably the first thing you read.
Yes.
And we could all wish it was clearer. I wanted to turn you to the principles. Before we get to the principles, let's look at the considerations. That's on page 6. And at page 6 in paragraph 4.1, the second paragraph there, it says, the former Royal High School demonstrates many of the key values of Edinburgh World Heritage Site, and the use of Greek rather Roman styles cemented Edinburgh's claim to be the Athens of the North. And you'd accept that's perhaps it could be a better phrase, but it's quite a pithy summing up of the contribution to OUV of this building.
I can see that, yes.
And then at the bottom of this page is possibly one of the most slightly glib statements of truth we've all had to deal with. The former Royal High School building has access difficulties which raise issues for any proposed public use. And of course, all of us now involved at any level in this case, witnesses or otherwise, are going, well, yeah, we sort of noticed that. Sensitively designed solutions to improve access and permeability will be encouraged. And then it says, solutions which make use of the wings of the building and exploit the changes in level will be considered where they respect the symmetry, classical power and simplicity of the buildings. Now, we can have an argument, and I'm not sure it's for me or you to have an opinion on this. We have an argument about whether any of these schemes respect the symmetry, classical power and simplicity of the buildings, but you'd accept that the Block 10 development brief requires that question to be answered.
It's certainly in the text, yes.
And given that this document could be better phrased, if as a reader one draws out from this a requirement that any scheme that's going to be compliant with this will respect the symmetry, classical power and simplicity of the building as one of the more significant factors that lie behind the principles here.
Well, it says solutions along those lines will be considered. It's not any more prescriptive than that.
Let's, well, what it says is solutions will be considered where they respect. So it's not saying we will respect them if they will only be considered if they respect the symmetry, classical power and simplicity. You see that?
Well, as I say, that's part of the text as opposed to perhaps more of the detailed guidance that follows later.
Well, let's look at Development Principle 1. That's on page 13. And the reason I want to just go to two parts of this is because I'm going to look at the figure 5, and therefore I don't want to sort of surprise you. So we have a first principle, which, of course, almost seems as a truism. But looking within that, there's a statement, the proposal should, and there's a list of 6 things that they should do. Now, the one I wanted to highlight is that they should encourage permeability and access to the campus through the provision of new public realm and improved accessibility to the campus and the main building. Now, going back to my comment about access, Scheme 1 and Scheme 2, one thing they do not do is put access to public realm on the site as a primary requirement, because most of the site, much more of the site gets built on, doesn't it?
There's more of the site built on. There is improved access to the site.
This would be the road the elderly solicitor is staggering up. Right.
Yes, amongst others.
Can we look at Principle 3? And again, this seems to mandate that development proposals should do various things. Now, again, I don't want to get into whether in setting terms, landscape terms, heritage terms, these are met. But simply on the third bullet point, because we've had evidence about that and there'll be more, the third bullet point says that schemes should explore the reuse of buildings, and of course Scheme 1 and Scheme 2 do that. And then it says, and limited development within the campus. Do you see Scheme 1 or Scheme 2 as limited development?
It's a matter of judgment. It was the amount of development proposed in order to make the Scheme 1 feasible.
Might that well be the issue? Because this document that was produced as part of the String of Pearls project was produced independent of and before the procurement exercise, the competitive dialogue, I think we're supposed to call it, took place. So this is this has planning status, unlike the procurement exercise.
It does, but as you say, it predates all the subsequent discussions that followed. So in appointing Duddingston House Properties as developers, there was reference to their proposals being compliant with the brief, and then there were extensive pre-application discussions with the council, of which this, amongst other things, would have been considered. And certainly on Scheme 1, changed their position on Scheme 2, but on Scheme 1, the Council's report committee confirmed the general compliance with the brief, certainly in use terms.
Is that the planning committee report on Scheme 1, or a different committee report?
Sorry, I was referring to the planning committee report, the development management subcommittee report.
Perfect. Right.
I'm just going to check whether I've got misheard. So you're saying that development management committee of Scheme 1 say that your scheme is compliant with the development with the Block 10 development brief. That wasn't my recollection.
I can probably take you to it if that helps.
I think we should just isolate that. So could you take me to that?
I think I've got this right here. Page 14 of that.
This is Scheme 1.
Sorry, this is Scheme 1, the 2015 report.
So that will be CD 419.
Yeah, sorry.
This be the top of page 15 of 136 of CD 419.
Yes.
Yes,
that's correct.
Where it says, in conclusion, in respect, I'm sure the reporters will read this separately, so let's not go through it in any great detail. In respect of SPP generally, local plan policy and the Princes Street development brief, the proposed hotel use is acceptable in terms of principle, subject to other policy requirements. So this seems to be speaking about the proposed hotel use rather than the scheme as a whole. Or ultimately it's a matter of the reporters.
Sorry, I think what I said earlier, certainly in relation to the principle of the use, I said it was compliant.
Well, I think that wasn't quite what I was saying. I must have been not clear enough. Can we go back to the development brief and figure 5? And I've just dawned on me, I'm looking at a black and white version, and you're going to have a colour one, as all the reporters. So I'll just find the colour one on my screen. Just for the benefit of everybody here, in Figure 5, there's some pink markings. It's got a pink feel to it. And if you're looking at a colour one, that's where we are.
Sorry, yes, got that.
Yeah, now, all I want to do is, whilst I appreciate this is a planning aspirations document and therefore certainly not scalable, it has within its western edge a ellipsoid shape covering the area between the top of Jacob's Ladder, including the western pavilion, the wonderful PSA trees and parking, and part of the road, which is described as public realm improvements. You see that?
Excuse me. Yes, I see that.
And you'll recollect there was a principle that related to permeability and public realm improvements on the site.
Yes.
So would one be entitled to think that whoever wrote this, and it obviously was approved by the planning committee eventually, had in their mind the idea that public realm should be going partly on the site and partly on what is now the street at the western end of the site, and that might explain why various people wanted the buildings, if there were to be any, to be set back at that location, because it would allow for public realm at the western end.
That may well have been what was in the mind at the time, yes.
Thank you. Now, I'm going to finally turn to one final topic, which is, you'll be unsurprised to hear, related to World Heritage matters. And could you please have, I'll get a lot of these documents together to save time, the World Heritage Convention, which is CD 514, the CES plan, CD 452, the local plan, CD 453, and I will stop there for a bit, and there's a couple more after that. I don't want to overburden your desk. So you've got the World Heritage Convention, let me know, and that's when we'll start.
Is that 514, Mr. McIntosh? Thank you. Got that, thanks.
Right. I wanted simply to go to, it's obviously a recital, and World Heritage statutes, international treaties are not obviously directly incorporated into UK law, but it's an interesting document, and that presumably has some weight, and I'll refer to it in submissions. But looking at the recitals on the second page, which begins convention concerning, and we have a series of italic first words, and it's the fourth considering after a recalling. It goes considering that parts of the cultural or natural heritage are of outstanding interest and therefore need to be preserved as part of the world heritage of mankind as a whole. Would you accept that the designation as a World Heritage Site in some way provides a very high level of recognition for an area that, certainly from the perspective of the public, and in a sense a small p political or civic understanding, a greater imprimatur of importance than the rather more mundane conservation areas, design landscapes, or even listed buildings? This is a high-level designation.
Obviously not a cultural heritage expert, but as a planning practitioner, I'm aware it's important to take it into account as a material consideration. It's mentioned in Scottish planning policy. I'm conscious it doesn't have the statutory status of some of the other heritage designations mentioned.
Well, indeed, and I understood that of course one has to. It is the UK government decided to implement it through the existing system, and therefore that might explain that. But let's look through some of the more significant tests that are going to be applied, just focusing on this. So if we look at CES plan, which is 452.
Got that, yes.
Now, CES plan at 452, I have somehow managed to close mine down. But if you could look at policy 1B, once I've opened mine up, policy 1B directly addresses the World Heritage Convention and OUV. And it requires that local development plans ensure, which is quite strong language, that there are no significant adverse impacts on the integrity of international and national built or cultural heritage sites, in particular World Heritage sites, and then it lists others. But do you see the fact that World Heritage is listed first, and that this is a requirement to ensure in the local plan, and it's therefore quite a mandatory assertion?
Yeah, I think I mentioned that in my various policy assessments. Yes, it's ensuring no significant adverse impacts on the integrity of those various designations.
And heritage assessors can have an argument about whether there are significant, but we'll perhaps not go there. And then if you look at the local plan, that's at CD 453. And that is, of course, ENV1, which I suppose we should look at more often. It's on electronic page 101 if anyone's using a computer. And whilst I'm sure nothing much turns on the order of policy plans, it's quite clear. Development which would harm the qualities which justify the inscription of the old and new towns of Edinburgh and of the Forth Bridge as World Heritage Sites, or would have detrimental impact on the site setting, will not be permitted. So it's a different language. It's now detrimental is the word it's looking for. But again, it's a clear policy that we have to consider and looking at the local plan.
Yes, and I believe we've done that through the various detailed studies that have been carried out.
Indeed, and you've said that, and I think we could all waste a lot of time if we went over it all detail. But let's look at the conservation area issue. So you'd accept that in assessing the conservation area test, the character appraisals are an important guide to understanding what is the character of a conservation area.
Yes, sorry, were you taking me to the policy?
I'm about to take you to the... Sorry. If someone could dig out for you 495 and 494, which are the two most recent Newtown area conservation area character appraisals, but whilst they're doing that, would you accept that when assessing the conservation area test, the conservation area character appraisal is an extremely useful sort of an essential source of guidance about what the character of a conservation area is?
Yes, in general terms, yes.
And this particular conservation area has some interesting language about the World Heritage Site. If we look at the most recent one, which is 495, and we go to page 4, there is text at page 4 on the left-hand side about the World Heritage status, and of course the reporters can read that. But I wanted to take you to the next part, which includes the statement of significance. Now, I think my submission is interesting and perhaps relevant that it's described in pretty superlative terms in the second paragraph. The conservation area ranks as one of the most important in the United Kingdom in terms of both architectural, heritage, urban planning, historic interest. Its significance is reflected in respect to the essential number of listed buildings, the number of tourists that visit the area, and its international recognition as part of the UNESCO-designated Old and New Towns and Edinburgh World Heritage Site. So whatever we learn from reading this document, do we not have pushed to the front that this is not only a World Heritage Site, but one of the most important conservation areas in the United Kingdom in the eyes of the local plan authors and approvers?
I perhaps missed a specific reference, but I understand your general point, yes.
And so we won't take you to the other one, but CT 494 has similar language, and perhaps the reporters can look at that. Now, listed buildings, I don't want to get into huge detail here, but the listed building, obviously the listing is an important part of understanding a listed building and its special character. And we can find a reference to the listed building, and I'm not sure I need to take you there, at the end of Mr. Wright's report, CD 47, page 107, and he's discussed that and what it means, and I'm not going to take you to it. But of course it's a 1966 document, and it predates the World Heritage Site designation, and you're aware of that?
Yes.
And so what I wanted to do is, I'll see if you'll accept it, and if not, we'll go and find it. In fact, it's pretty safer to go and find it. Let's go and look at CD 47, page 107, because I think it's fairer to make sure you see it before I put it to you. So, Well, wait till it comes.
Sorry, what was the page number again, Mr. Mayor?
Page 109, we're well into the text of the notes. It's the page that starts glazing and has notes as a heading halfway down.
Sorry, CD 47.
Yes. So CD 47, Mr. Wright's statement. Go to almost to the end, and there are unnumbered pages at the end, and you'll find closely typed text, the original listing for this building.
Yes, sorry, it's after page 101 in my version, statutory list entry.
Yes, and so if you go to the page that's got at the top, first word is glazing, etc.
I've got that, yes.
And then if you go into the notes section, what I was struck by was if you work through it, now look down the left-hand side, you'll see the word Cannon Mills about 15 lines down, and go a bit further, and you'll see the word Slopes of Carlton Hill on the left-hand side. Do you see those?
Yes.
Right. And then the next line, this time he proposed a Greek Doric building which fully exploited the picturesque potential of the site. The decision to use the Greek rather than Roman styles was significant, and architecturally it cemented Edinburgh's claim to be the Athens of the north. And then further on, we have reference on the left-hand side to the words dramatic setting, and it says, inspired by the dramatic setting and the backdrop of the unfinished national monument, based on the Parthenon at the Acropolis in Athens on the hill above, Hamilton created a monumental composition based on the temple, e.g. the Prophylon at the Acropolis and the Lesser Temple. Now, I want to hold that in our thoughts and go and look at CD 485, which is the nomination document for the World Heritage Site. Now, I simply want to take you to page 108, which is electronic page 109, which is the entry for this building.
Did you say CD 485?
Yes, now remember, this is the one which I produced a full version at the beginning because there was a sort of...
My electronic page ends
It ends at 39. It's much more interesting afterwards.
Yeah.
Now, the entry here is the noblest monument of the Scottish Greek revival and perhaps the single building which most justified Edinburgh's epithet of the Athens in the north. The design was conceived integrally with a national monument on the hill above, and the central Doric temple contains a splendid hall with coffered seating, oval seating and cast iron columns. Now, the reason, you've not decided, the reason that I raise that is, do you see there's a clear read across between the reasons that this building was seen to be an important aspect of the World Heritage Site nomination, and some of the reasons that it was seen appropriate to list it?
Yes, there's some common ground.
So all I want to take from you is this, and I could go and look at the garden design, landscapes and everything else. I think we could probably stop here. I think I might have made the point. That whilst World Heritage is not a specific statutory derivation, almost every test that the Council and now the reporters and Scottish ministers have to address has somewhere built into its substructure, and sometimes rather more overtly than not that, the fact that this is a World Heritage Site and contributes significantly to outstanding universal value. Would you accept that?
Yes, and I think that's been well understood by us.
Well, Mr. Wright didn't reference that in his document. Have you read the nomination document? Because this particular version was supplied by me, it wasn't an original document that came out of the appellants.
I haven't read this document, no.
I think that probably brings to an end everything I've got to ask you, but because last night I had such sudden shortage of staples in my house, I must check I haven't put these in the wrong order, so just bear with me. Thank you very much, Mr Mappin.
Thank you.
Thank you, Mr McIntosh. Mr Innes, you'll have a few questions. Okay, let's take our break and we'll resume at 11:10. We understand that Mr Mappin has some information at hand that Mr Thompson requested yesterday. Mr Mappin.
Thank you, sir. Yes, conscious, Mr Thompson, in your questions yesterday, you took me to some matters in my evidence principal inquiry statement and planning statement, I recall in Scheme 2, and we were discussing matters relating to the statutory test relating to conservation area assessment or the assessment of impact. I said that while perhaps there had been an omission of the reference to specific statutory reference, it was covered at various points. The substantive matters were covered in various points, both in my inquiry report, the previous planning statements, and given the nature of how we've addressed heritage evidence, there are significant references in the environmental statement and Mr Wright's work. Now, I have been through all of that again last night, and I did have multiple references for you. I didn't know if you wanted me to read them out longhand or find a way in another form of submissions of submitting them to you and everybody else.
Thank you very much, Mr Mappin. I would be perfectly happy if you could produce them just in a sheet of paper, which can then become an inquiry document or perhaps as part of your evidence, if that's...
Well, whatever's easiest for everybody, sir.
I understand there's quite a list, so it might be better to do it that way rather than read them out.
I'm delighted there's quite a list in the circumstances, sir, but if there is, then that's fine.
And thank you very much, Mr Mappin.
Thank you.
Thank you both. Mr Innes.
Yes. Good morning, Mr Mappin.
Good morning.
In terms of the evidence that you've given to this inquiry in relation to the compliance with policy, and given the topic matters that we've dealt with, is that do you rely on the evidence of the witnesses that have given evidence on behalf of the appellant in reaching the planning conclusions that you do?
Not in all respects, but in relation to specific matters covered by their expert areas, yes.
Yes. And insofar as the conclusions that you reached, that is based on the written evidence that was submitted both in the inquiry statements and in the context of their preconditions. Is that correct?
Yes, correct, yes.
Thank you. Now, I just want to check with you your understanding of the extent of the comments made by your collective team in relation to the scheme that has both planning and listed building consent, which we've been calling the trust proposals. And I just want to summarise what my understanding is and see if you agree. In terms of Mr Wright, he's got a document, APP39, where we get the detail of it, and he raises three substantive issues. 5.4.4, interventions into the building. 5.4.9, some comments about the glazed eastern playground. And 5.4.10, issues regarding northern setting of impacts on the setting to the north. Is that correct? Is your understanding?
Yes, that's my recollection, yes.
And Mr Maskell, in APP 40, in Section 5, deals with, again, interventions to create the foyer and also setting to the north. Yes?
I don't have the document in front of me, but I'm happy to take that, yes.
And Mr Taverner, or Professor Taverner, yesterday, whose evidence we heard at APP 45, which is essentially his largest statement. Again, he raises issues relating setting to the north, the foyer, and he also comments on certain design elements of the trust proposals.
Yes.
Yeah. And finally, in terms of the suite of witness, Mr Collins would have given evidence on two matters directly the funding and the sustainability of the use. That's the two matters that he deals with.
Yes.
So in that context, do you agree that that sets the parameters of the matters which you have put at play in the context of this appeal in relation to my client's proposals?
Yes, that's correct.
And of note, Mr Van Grieken did not mention the trust proposals in his evidence, correct?
I think that's correct, yes.
And equally, Ms Tweedy did not raise any matters in her evidence. Is that correct?
I think that's correct, yes.
Okay. Now, I don't think this should take long. I just want to pick up a few policy references with you and to just understand your take on them. Could we first of all look at HESP, which is CD 498? And if we go to Appendix A, which I think is page 53 of the document electronically.
Sorry, Mr. Ennis, CD 498.
Yes.
Was it?
And if you go to page 51 of probably the document in hard copy, is that correct? You've got Annex 2.
51 Annex 2.
Yeah. And do you see there that that's the criteria for determining whether a building is of special architectural or historic interest for listing? Do you see that?
Yes, I see that.
So that would be the correct place to go and find the definition of special interest. Would that be right?
Yes, I think that's totally correct, yeah.
And we see that under paragraph 1, the criteria can only provide a framework within which professional judgment is exercised in reaching individual decisions. Do we see that?
I see that, yes.
Yeah. So again, it wouldn't say that this is a prescriptive approach. It's setting out factors that are likely to influence the ultimate professional judgment as to whether or not a building is of special architectural or historic interest for listing.
Yes.
Yeah. And we see there that age and rarity is one of the criteria, and it states there the general approach, but equally that general approach may be overturned by professional judgment. That's the point, isn't it?
Yes, I think if the circumstances justified it, yes.
And then goes on in the second section to identify the architectural or historic interest, and under that chapter it talks about the various aspects of the interior, the plan form, the excellence and innovation, the material design quality, all those matters relating to the building itself.
Yes.
And then it goes on to setting, might also be important. The context of which the structure sits can be a critical factor in its evaluation. It invariably accounts for its form and should not be underrated. So it's suggesting that it's not just the physical, it's its context that's important.
I can see that reference, yes.
And then we've got close historical association, and it then identifies that there may be aspects of our past which may elevate and provide further justification for a listing.
Again, I can see that, yes.
Yeah. And then it's got a final section, is it's working with the principles, and it then sets out what might be a sort of practical approach for some of the other issues to come into play. Yeah.
See that, yes.
Now, in terms of, I don't think we need to look it up because I think Mr. McIntosh went in some detail with the listing particulars with you. But would it be fair to say that both the building, its setting, and close historical association were all matters that were identified as relevant to the listing of the Royal High School?
I think I accepted that point earlier, yes.
if you could now go to SPP CD 459 and go to the end of the document at page 74, and if you could have a quick look at the definitions that are provided at the back, please. And I'm particularly looking, if you could have a look at the definition of setting, please.
Top of page 75, yes?
Yes.
I see that, yes.
Yeah. And if you, I'll give you a chance to read it, and then I'll ask you a question.
Yeah. Read it, yes.
Would you accept that SPP encourages us to take a broad view on setting, and that it's more than just the immediate surroundings of the site?
That's what it says in this definition, yes.
Yeah. And equally, it identifies that it could also include how it was intended to fit into the landscape of townscape, which seems entirely appropriate in the current matters that are before us, isn't it?
I can see it includes that reference, yes.
And you think that's relevant to what we're discussing at this inquiry?
Yes.
Yep. And equally, then, we've got to look at the view from it, or how it's seen from areas around about, or the areas that are important to the protection of the place, site, or building. Yeah. Would it be fair to describe that as quite a holistic approach to the concept of setting in the context of the SPP?
Yes.
Yeah. And if we move on to other matters which are likely to be material considerations, further considerations, CD 502 is the setting document managed change. Now, I don't think we need. There's nothing turned on the particular wording. I suspect, in preparation for this inquiry, you've read the document. Would you agree equally that it sets out a very broad range of factors that can contribute to the setting of a heritage asset?
Yes.
Yeah. So it's consistent, again, taking a broad view of the heritage asset and working out, essentially providing an opportunity that each setting has to be considered from a whole range of factors, and some may or not may be relevant to the particular asset in question. Yes?
Yes, I can see that. Well, that's what it says.
Mm-hmm. And just finally, whilst you've got that section of the historic guidance out, one of the other advisory documents which are likely to be a material consideration, because it's part of the Managing Change series, is the extensions. I think that's CD 505.
I've got that, yes.
Yeah. And in your view, would this be a material consideration?
Yes.
Yeah. Now, I'm not going to take you through this whole document or put detailed questions to you, but if I go to the general principles, and we see in the first bullet point, there's a statement that an addition or extension should play a subordinate role. It should not dominate the original building as a result of its scale, materials, or location, and should not overlay principal elevations. Do we see that?
Is that the key issues on page 2?
No, the general principles on section 4 of the document, and the first bullet point.
I see that, yes. Sorry.
Yeah. So those are general principles which no doubt would be part of an analysis of whether the development accords with the general principles or not. These are guidelines, isn't that correct? Yeah.
Yes, they take it into account as a consideration, yes.
Now, Mr. Mappin, we have something in common. We've both been to the Rosewood Hotel in London. And I was just going to take you back to your trip to the Rosewood Hotel. When did your visit take place?
I've been on a few occasions, most recently about 4 weeks ago.
Okay. So you have some familiarity with the hotel and its various entertainment facilities, shall we say?
I've been around the hotel with the management. I've unfortunately not taken part as a customer up to any great point.
So we're just trying to get your general impression of the hotel. Would you say someone like the Scarf's Bar could be described as fairly cool and relaxed? Would that be the impression that's given by the
I'm sure that might extend to some clientele, yes.
But in terms of your impression of the hotel, did you get the impression that it was this quite cool and relaxed place with a young staff that were enthusiastic in what they were seeking to achieve in terms of hospitality?
Well, I can only give you my experience, which was, as I say, was limited from a couple of short-term visits, and unfortunately not as a customer. My impression was of a very well-run establishment with impeccable levels of service, but in a very relaxed and comfortable environment.
Perhaps we could describe it as cool, relaxed, and reassuringly expensive.
I'm glad to say I didn't spend very much money at it.
And noting the receipt that's lodged as RHSP T8 was lodged in respect of a purchase on the 11th of the 7th, 2018. And I don't know about you, Mr. Mappen, but do you recall what was going on that evening?
Sorry, the date again, Mr. Minister?
11th the 7th, 2018.
No, sorry.
England might have been not progressing to the World Cup final. Is probably the best way of describing it.
I didn't recall that as the exact date, but I'll take that from you, yes.
Now, that was an evening where most of London were enjoying hospitality in various hostelries. And in fact, there were queues outside most of the hostelries, but not at the Scarf Bar. It didn't appear to have that character of being a local place where people would go and enjoy watching football, because it's just not that character, is it?
I wouldn't have thought so. I didn't see a TV in it.
Come back to one last matter, Mr. Mappen. We've discerned what your client's witnesses have said about my client's scheme, and I think it would be fair to say that their comments in relation to the evidence that they've given before this inquiry has been universally negative. Would you accept that?
Yes, and in relation to those specific matters, yes.
Now, if there were positive aspects of my client's proposals relating to cultural heritage, would it be fair to say that that's not a matter which you have not taken into account because you simply haven't had any of those, none of that evidence was given by your witnesses?
That's correct, yes.
Take one example is if we take one Regent Terrace, it's an easy thing to look at. Your clients have had to do fairly extensive modelling of whether the development harmed or reached the stage where the lighting at the rear of Regent Terrace breached residential quality standards. You'll recall it's in the environmental statement, and no doubt in the planning terms you'll be aware of that.
Yes.
And just taking one example, in the design and access statement in relation to the Royal High School Trust proposals, you'll find, rather than being harmful to daylighting, that in fact the rear of One Regent Terrace benefits from more sunshine in the late evening to enjoy one's gin and tonic in the garden with the trust proposals than the current position.
I don't recall that specific reference, but I can accept that, yes.
And equally, if there are wider benefits to the landscape setting of the Royal High School from the trust proposals, those have not been taken into account in your evidence. Is that correct?
That's correct. The focus from our perspective was addressing the policy matter raised about whether there's an alternative use. We focused on what we considered to be the critical elements in that regard.
Thank you very much, Mr. Mapper.
Thanks, Mr. Innes. Ms Nibble, anything from you for this witness?
I do have a couple of questions. And could I ask you please to have CD 031 and CD 428? CD 031, it is figure 13.59, view 17. I don't think there's a page number. Yep, thanks. And in CD 428, it is image 3. Now, unfortunately, this is not numbered either. The images come after the text in the hard copy, and it is the third image. Yes, the aerial view. And we're back at the little back door. Sorry, has everyone got them? So here we are at the service entrance again. Residents' associations tend to be very involved with lighting and rubbish. And here we are, nothing different here. But this is a very, from the aerial view, you'll see this is the picture that really gives us the direct connection, very visually, of how close the Thomas Hamilton building is to One Regent Terrace, the terraces, and although obviously Regent Terrace is the most important in connection, you can see how they all connect. So even though I live right around the very far end of Royal Terrace, we still feel connected to this building. And the way in to Regent Terrace, and all the way around if you're coming from that side of town, is past the Hamilton building and into Regent Terrace at that fork where Regent Road heads down the hill. There are bollards there now as well, which protect it, mainly because of the American consulate, which is at the end of the street. But there is no lay-by, and any lay-by that's been talked about would be at that end of the street. And it seems to have been, relegated hugely that this tiny door with 30-odd deliveries throughout the day at all times is not much of an issue. But for us, this is the gateway to Regent Terrace. I just don't see the match. I don't see why it's been given such lack of information, and no one has particularly seemed to answer the questions of how important this doorway is. Can you try and fill me in, please?
Apologies. I'm sorry if you feel that it hasn't been given due attention. It was the revised proposal, Scheme 2, did change the service arrangements away from the vehicles entering through the change to the building fabric here in order to address concerns in that regard. There were multiple discussions with the Council's Roads Department about how that would work, the technicalities of it, notwithstanding your comments about your perception of the effect on neighbours. So we believe that there's a technical solution for that that doesn't interfere with the movement of existing vehicles. The vehicles wouldn't come along Regent Terrace. They would come in and out of the manoeuvring area here. There would be no obvious, there's considerable distance away from Regent Terrace. So the amount of disturbance would be very limited.
Potentially the noise levels might be quite low, is that what, but it's not just that, is it? It's the fact that when you're walking along here, these terraces are the longest continuous terraces, Regent Terrace and Royal Terrace, category A listed in Europe. And I don't think there's much Georgian architecture beyond Europe, so I would like to say they're the longest Georgian terraces in the world. Regent Terrace was there first. It's got a little bit of a marker. And this is, from town, the walkway for all the residents and many tourists past this beautiful building and into a beautiful terrace. And it's going to, this is what is the wider setting. The wider setting for us comes right down to that pavement and round the building and along. And you say at 3.9 and in the proposals would have limited impact on the special interest. And on balance, the development would make a positive contribution in overall terms to the setting of the listed buildings. But I think you'd have to agree with me that that's not true. There's no positive benefit for us here.
I think in considering the effect of the overall development, the number of factors to take into consideration, I think if you like, the physical impact of vehicles and people moving deliveries in and out against the backdrop of what already happens on Regent Road wouldn't be, in my mind, significant. And also there's a wider consideration about bringing that building back into active and positive use. And the servicing is a consequential requirement of the hotel. Now, there are recorded, this was feedback that we had at the time of the applications from the police about the positive impacts on antisocial behaviour in the area. So those are just part of the wider consideration of the impact on the building and on the area.
That's kind of you to think of us like that, but I maintain that for Regent Terrace and the residents, and for tourists and movers on foot, certainly around Edinburgh, that this is a negative impact and it should be recognised as such. Do you agree?
That's not my position, though.
Right. Thank you very much.
Thanks, Ms Nimmo. Just a few questions from us, Mr Muppin, before we hand you back to Mr Steele. At paragraph 2.7 of your precognition, you say that the music school proposal wouldn't offer the same level of public access as your client schemes. Could you just elaborate on that a little?
Yes, well, the hotel proposal, while not necessarily being a 24 hours, 7 days a week operation, would be open on a daily basis, and late into the evening there would be public access into the site and into the building through those operational hours. My understanding of the music school, without, I call it the RHSPT scheme, would be that would be a private institution where access would be limited and controlled.
But as I understand it, the Trust is proposing a performance area where members of the public would be able to access that. You say at limited times, presumably.
That's my understanding, yes.
And at paragraph 3.7, you say that evidence has been presented to confirm that the level of development proposed is the minimum required to make Scheme 2 viable. Do you say the same for Scheme 1 or not?
There's detailed evidence coming in session 2 from Mr. Kett of HVS that deals with the viability of both schemes.
And do you anywhere draw on that evidence in relation to Scheme 2, Scheme 1 rather?
If you can just bear with me a second.
Sure.
So there was reference in planning statement number 1 to the report, the viability report done at the time. I've certainly focused on Scheme 2 and on the inquiry report. And I have drawn again on the detailed evidence given by, or that has been submitted by Mr. Kett of HVS and Mr. Finney of Colliers in this respect.
Okay, thanks for that. And just going back to the issue that we discussed earlier, and we had to make a ruling or two, just so that we can be clear for now anyway, do you say that the identity of the operator is a material planning consideration?
The nature of what is proposed is material. I think the evidence relates to that, and that draws on the operational aspects of Rosewood. The proposal is specifically for a hotel of a world-class international standard. The operator selection was carried out on that basis, and that's very much at the heart of what this proposal is about. And there are key aspects of what is in the design, the proposed operation inside the building, the features, the quality of the overall development, and in relation to operational aspects such as the commitment to an arts and culture strategy. So it's about the impact on the building, the physical impact on the building and the operation of it, and that flows from the identity of the operator.
Okay, thanks for that. So, final question, and just to conclude on that. So, I've noted what you've said on that. So that leads to the question: how would that be controlled in planning terms? And I know that we'll come to that in detail at the hearing session, but I'd like to hear your outline view, if you like, on that just now.
Well, there are certain matters I believe are in the hearing statement in that regard, and certainly in relation to addressing specific matters such as the commitment to an arts and culture strategy. There could be controls over the internal layout, number of rooms, size of rooms, all matters reflecting what we've led in evidence and shown in the proposals, and I believe they could in part or in whole, all be framed in suitable planning conditions or in an agreement if that was required. There may be other matters that we could explore in detail at the session on conditions and agreements.
Okay, thanks for that, Mr. Mappin. Mr. Steele.
Mr. Mappin, if I can just focus firstly on the learned reporter's questions. Firstly, so far as public access is concerned, would there or would there not be public access at all times to all or virtually all parts of the existing building if the hotel was developed?
Yes, there are slight differences between the two schemes in relation to access to the lower areas, but
well, that's why I said virtually all. Well, in particular, if I can just select but two examples, the east and west octagonal rooms, which are to the east and west of the assembly room, would there be public access to those?
Yes, there would.
And without going to the plans, are there also, depending on which scheme you go to, publicly available bars, and in one scheme a whisky bar at lower ground level? Is that correct?
That's correct, yes.
Would these all be publicly available?
That's my understanding, yes.
Now, in comparison with that, what do you understand to be the public ability to access the building in the event that the trust proceeds?
Well, my understanding that there would be access when there are specified events that are open to the public.
Which we understand are concerts, is that correct?
Yes, that's correct.
Sorry, presumably these would be ticketed events, being a concert.
I would expect so.
And do you know how frequently these may or may not occur?
I believe there was reference to some frequency. I can't recall what it was. Not daily.
And in relation to access to the building, would that give unrestricted access to the entire building as exists, or restricted access, by which I mean restricted geographically?
I believe the access would be limited, yes, restricted.
And is that particularly sensitive? Because obviously it's going to be operating simultaneously as a school.
I would expect that was to be the case, yes.
Now, if one is carrying out any fair evaluation as to public access to the main building, in whose favour do you say the balance of advantage lies?
I think clearly in respect of the hotel proposals.
Thank you. Now, so far as viability is concerned, did I understand you to suggest that one of the witnesses in session 2 would deal with that?
In depth, yes.
And am I also right in thinking that you return in session 2 with a new precognition, which may or may not rely on that evidence in detail?
That's correct.
So that, in fact, in relation to the viability issue, did we intend to deal with that at a later stage?
Yes.
If you're content with that, sir. Now, on the question of the materiality of the operator, firstly, do you or do you not say that it's a material consideration that this will be a world-class hotel?
Yes, insofar as that informs the quality of the overall development and proposed operation.
And have we led evidence in particular from Mr. Gibb, I think it was, that the hotel has been designed to be suitable only for that type of operator, namely a world-class hotel?
Yes, and that's my understanding as well.
Does it follow, for reasons which he explained in detail in his evidence?
Sir, I have to again raise the question of leading. I mean, I know ultimately it would matter for you how much weight to give to any of these answers, but and I know Mr. Steele is trying to be fast, and I appreciate that, but I just raise my concerns again.
I would tend to agree. I appreciate why you're taking that line.
I tend to agree as well, sir, but on the other hand, I'm trying to make some progress in this, and I really, really didn't think this was controversial because we've led detailed evidence about it. But I can deal with it another way, much more slowly. Mr. Mappin, do you recollect the evidence of Mr. Gibb?
Yes, I was here for the evidence, Mr.
What did he say about the reason for the design and the standard to which the hotel was designed?
Well, the design has been process has been carried out in consultation with Rosewood as a specific operator.
And do you recollect whether he did or did not give evidence about the suitability of the design for a budget-type hotel?
Yes. Yeah, I can't recollect it in detail, but I believe he did, saying that it wouldn't have been suitable.
For reasons that he explained in his evidence, is that right?
Yes.
Right. Now, so far as control is concerned, obviously we'll be dealing with conditions, Section 75 later. But would it be possible, in your professional opinion, to have a condition, firstly controlling the minimum or maximum number of rooms in a way that would be consistent with a particular level or type of operator? That's the first question. What do you say about that, Mr. Mapp?
Yes, it would be.
Would it also be legally possible to have a condition about the continuing, about the availability of the public circulation space in the way that we've heard about?
Yes, I believe it would.
Could we also have a suspensive condition that no development could or should commence until an appropriate agreement has been put in place with the Council as to certain specified matters, such as the suitability of an operator? Any reason we couldn't do that?
Can I just raise a concern I have with that question? Because the suitability of an operator has been something that I'm not aware of evidence about why, other than the wonderfulness of them, that Rosewood were chosen. And when I attempted to delve, perhaps in some people's eyes, too deeply into the numbers, Mr. Steele objected. If we're going to have evidence about the suitability of Rosewood, perhaps we should have had it before now. And so I'm concerned about the basis for that question, because there's not been a lot of evidence about the suitability of Rosewood or anyone else.
I think I probably led Mr. Steele into that with my question on how the quality of the hotel, if you like, would be controlled. So,
I see that. So now you remind me, I see that. So my apologies for interrupting.
I do wonder if my learned friend could just bear with me. Now, I haven't even mentioned Rosewood. Now, Mr. Mappin, can we go back, please? Because I've rather lost my train of thought. Would it be possible to have a condition along these lines that no development should commence until there is an agreement by Section 75 or other means with the Council as to the suitability of an operator? Is there any reason why we couldn't do that, particularly in circumstances where the Council are the landowner?
If conditions relating to the matters already mentioned in relation to layout, public access operation weren't sufficient, that might be possible, yes.
And in addition to that, I was going to say the reporters, but actually it's the ministers, I suppose, could issue a notice of intent subject to an appropriate agreement being framed, including in particular provisions in relation to that issue. Would that be possible, do you think?
Yes, it should be.
And do you have any knowledge whether the credentials of Rosewood have been supplied to the Council on a confidential basis? Do you know that or not know that? Or do we leave that to Session 2?
There's been material submitted with the planning application. I'm not aware what else may have been submitted to the Council.
So, in short, in this point, do you think there's a difficulty about securing, by one means or another, or a combination of means, the nature and type of operator that there will be if the hotel proceeds, with willing parties, of course?
Given that is the basis of the proposal, I don't see any difficulty with that.
Can I go back, please, to ask you one thing, or perhaps two questions about my learned friend Mr. McIntosh's questions about rubbish. If we look at document CD 706, which is a plan can you identify where the rubbish from the trust scheme will be serviced? To save time, and I hope there won't be an objection about leading, is it through the same door? And does it appear, I may have got this wrong, and perhaps you've got this wrong as well, but does it appear that the pavilion's been used for a bin store?
I think that's what's shown on this plan, yes.
Can I please deal with one issue very, very briefly? Could you look, please, at document 186? This is the letter from Pinsent Mason. And while that's being brought to you, Pinsent Mason are, I'm sure you'll agree, and I'm sure Mr McIntosh will agree, a reputable firm of solicitors who can be relied upon. Would that be fair?
I think that would be fair, yes.
Do we see in that letter that they advise that the agreement between Duddingston House Properties and the Council has been assigned to a partnership known as Carlton Hill Hotel Limited Partnership?
Yes, I see that.
And do you know who are partners in that partnership?
I understand it to be Duddingston House Properties Limited and Urbanist Hotels Limited.
So that if we turn back in that document to the background page, page 1, which was put to you, if we look at paragraph 1.2.
Sir, an issue has arisen with the answer to that question, and I would seek permission to lodge a late document. But I'd be grateful for the opportunity to discuss this document with Mr Steele before I lodge it. I'm concerned about the accuracy of the last answer.
Yes, we would expect you to discuss that with Mr Steele in any case before trying to lodge. So happy for that to happen.
I wonder, sir, if I can continue with my re-examination. Meantime, at the moment, I'm asking about the understanding of this witness. And I don't think that is an appropriate time to interject with a new document. Could we go to paragraph 1.2 of 186, please, Mr Mappin, where we see that Duddingston House Properties, in conjunction with their partners, Urbanist Group, continue to pursue, etc. Is that consistent or inconsistent with your understanding?
No, that's my understanding.
And in line 3, you're asked about the use of the word the developers. What do you mean by that?
Perhaps unhelpfully, but it was interchangeable with the applicants at the time.
To you, in a planning context, is the fact that they have formed a partnership called Carlton Hill Limited Partnership Limited material or immaterial?
I don't think in a planning context it's material.
Now, separately, do you understand whether the developers, by which I mean in this question Duddingston House Properties and Urbanist Group, who have formed a partnership, known as Carlton Hill Hotel Limited Partnership have any agreement with Rosewood. Are you aware of that?
Well, I've been advised by them that there is an agreement, yes.
And it is your understanding that that is a legally binding agreement with Rosewoods?
I haven't seen the agreement, but I'd taken it that it would have been, yes.
Let's look, please, at CD 336. Firstly, who is this letter from? I realise, of course, Mr. McIntosh characterises him as a salesman, but in fact, who is this letter from? Mr. Mappin.
The gentleman's name, Radha Arora, and I understand he's the president of Rosewood Hotels and Resorts.
And do you think that might possibly be a man of some integrity?
Sir, I have to object to that question. And I have no doubt that Mr. Aurora is a man of some integrity, but it is an odd question to ask of a witness.
Thank you. Well, if it's accepted, we can move on. Mr. Mappin, could you just read out the first sentence of the letter, please?
Yes. Rosewood Hotels and Resorts is pleased to have been appointed by Duddingston House Properties and Urbanist Hotels to operate an ultra-luxury hotel at the former Royal High School in Edinburgh.
What do you think is meant by the use of the words "to have been appointed by"? What do you think that means?
I've taken that there is a formal agreement between the parties.
Is that consistent or inconsistent with other information that you have?
I think that's consistent.
Well, let's try this from the other end of the telescope. Mr. Mappin, can you imagine why on earth Mr. Aurora, President of Rosewoods, would be writing such a letter unless he had a secure legal position? Can you imagine that?
No, I can't, and consciously also spoke at the Development Management Subcommittee that followed that period.
Sorry, could you...
Sorry, he also spoke at the Development Management Subcommittee for the first application.
And how was he? How did he represent himself at that subcommittee?
He spoke in support of the applications for planning.
And why do you believe that he did that? Did he just happen to be passing, or perhaps was there another reason?
No, I recall he flew in from Hong Kong specifically to do that.
Does that tend to indicate to you that he does or does not have a secure legal position if he jetted in from Hong Kong to speak about the proposal?
I'm going to object to that question. I'll take it slowly because I don't want to misspeak. I asked questions of Mr. Mappin on this topic, so I quite appreciate it's appropriate to raise it in cross. However, no such document has been lodged. Mr. Mappin, whilst he is, no doubt, an accomplished planning consultant and deeply knowledgeable about this project, is not a lawyer. He's told me he hasn't seen the legal agreement, and I'm not sure it's fair to put a question to him about the judgings of an action of a man he hasn't, about a document he's not seen. It goes well beyond his expertise and knowledge, I would suggest. If Mr. Steele wishes to lodge the document, even with redactions for commercial terms, if he thinks it's necessary, given our points, then he can do so. But to ask whether Mr. Mappin, with all due respect to planning consultant, has a view about the nature of a commercial arrangement between somebody else and another company in a document he hasn't seen, I would suggest he's perhaps going a little bit far in terms of his knowledge.
Sir, I can't see the harm in asking an impression from Mr. Mappin about the motivation for somebody flying in from Hong Kong. I simply can't see the difficulty about that. I'm not putting a legal document to him, and it seems to me that with the experience he has, he will know how often clients fly in from Hong Kong on a whim.
I think we've probably got as much as we can on this line.
Sir, I would like to suggest a short break. I'm very concerned about one of the answers given. I've sent by email a document to Mr McMurray. I don't know whether he's online there. He certainly has his device. I'd like Mr Steele to see it. I'd like to have a discussion. I don't want to put Mr Mappin in any greater difficulty, given what I think he said, and I'd be grateful if we could have a 10-minute adjournment just to discuss this, because
perhaps I can finish the re-examination first, sir, if that would be possible.
I think I'd like you not to lose the flow of your re-examination. Is it important, though, that we don't close the examination?
I think it is, because one of the answers that Mr Mappin has given on the document I have, that, as Mr Steele observed, I found on public access information online, directly contradicts the information that Mr Steele put to him and the answer he gave. So either Mr Steele may have incorrect instructions, and I wouldn't want Mr Steele to be further embarrassed by putting a question which I don't think is accurate.
Shall we proceed with your re-examination, but we won't close that before having a break?
Well, I'd be grateful for that. So there's just one further matter, Mr Mappin, and it relates to the document 51. I think that's an appellant's document 51, whether you need it or not to have before you. But is that a further letter from Rosewood from Mr Aurora? Perhaps you should have it before you. Taking the matter briefly and no doubt leading, it states this: I'm writing to reaffirm the commitment of Rosewood Hotels, etc. What do you think that means, Mr Mappin?
Well, the letter has been sent so that the then forthcoming inquiry was fully appraised of Rosewood's continuing involvement in the project. And I would understand it, and when I say I understand, I'm not suggesting I've had first-hand inspection of these documents, but my understanding from our clients is that's because there is an agreement between them.
Now, if one just simply, this is the final question on this particular topic. If one looks at this from the planning point of view, planning consultancy point of view, which is yours, drawing all of these strands together, do you doubt or do you not doubt the commitment and determination of Rosewoods to proceed if consent is given?
Insofar as I can, I don't doubt it, no.
Now, you were asked a number of questions about dates, Mr Mappin, and I'm just to save time, and if there's an objection, so be it, but to save time, I'm going to put 3 dates to you and then ask for you to agree with them or disagree with them. The pre-inquiry meeting took place, and there should be nothing controversial about this. The pre-inquiry meeting took place on the 20th of July. A CIST was requested on the 20th of July 2016, I should have said. A CIST was requested on the 26th of August 2016, and the POAN notice was served or circulated or whatever it does on the 16th of September 2016. Now, Mr Mappin, do you understand these dates to be accurate or inaccurate? And if inaccurate, what do you understand are the relevant dates? If you need time to look at it and consider it, it may be you can revert after the 10-minute adjournment or so, without speaking to anyone, obviously, or maybe you can answer the question now. I don't know.
I could check, but that sounds accurate to me.
Fine. At this stage, sir, I have no further questions in re-examination, subject to whatever may or may not have been sent to Mr McMurray or received by him in the last few minutes, about which I absolutely reserve our position. And lest there be anything in this, sir, I'd perhaps suggest 15 minutes to look at it, because I need to look at it, read it. I don't even know what it is, and also it seems to be some certificate. Looking over my shoulder, and take proper instructions on the matter.
Okay, I'll give you 20 minutes. How does that sound, Mr. Steele? So we'll break until 12:30.
Firstly, my submission is that this document, if it was to be relied upon to any extent, should have been lodged timelessly. If there were good reasons for that not being possible, at the very least, for a variety of reasons, including, I have to say, professional courtesy, I would have expected the matter to be drawn to my attention. For this document only to be produced midway through re-examination, in my submission, is, at the very best, very unfortunate. Having said that, sir, I have had a few minutes to look at it. I am not an accountant. I am not a specialist in these matters. But as presently advised, I do not see any difficulty either with my question, of which I'm not in the slightest embarrassed, nor with the answer. I see that subject to reviewing the precise question and the precise answer on the live feed. Because this document does, on the face of it, seem to confirm that Duddingston House Properties and Urbanist are indeed partners in Carlton Hill Hotel LP. I wonder if I can finish without interruption off stage. In addition, it does seem to disclose that the funder is also involved, as one might expect. Now, sir, if you think that the matter is relevant, and in my submission it's entirely irrelevant in the current context, and was a deliberate attempt to ambush me and Mr. Mappin in the midst of re-examination, which is at best unfortunate. If, sir, you feel that this document is relevant, then we would propose to address it in session 2 of the economic session, thereby not disrupting the flow of the inquiry. It is obvious that this certificate is not a matter for Mr. Mappin, and I should have said at the outset, having said it was one document, as soon as we rose, I was handed 2 separate documents, not one. A second one, I'm bound to say, I don't even understand what it is. So there we have it, sir. My motion is that this is entirely irrelevant. It should never have been raised. And if this is persisted with, sir, we will deal with it in detail in the economic session. It may be we'll need to lead another witness. It may indeed be that we will need to lodge other documents. But at the moment, sir, I'm mystified as to why this should be raised.
Mr. Steele, why do you say it's relevant? Mr.
Yes, so I asked some questions, and obviously I knew that I had not lodged documents, so I only took them as far as I could go, and Mr. Steele interjected. When it came to re-examination, I was listening carefully to Mr. Steele's question, and Mr. Steele's question to Mr. Mappin was whether Carlton Hill Hotel Limited partnership was a partnership between Duddingston House Properties and Urbanist. Now, that struck me as an odd question to ask. Now, it may well be at the time that Mr. Steele, well, he didn't have this document that I've given him a copy of, and I appreciate that if he didn't have it in front of him, he might not have known what it said. But the document I have, and I do seek permission to lodge it now. I'm happy to be addressed in session 2, and I don't want to interrupt the flow of matters. It's a double-page document. It comprises the certificate of registration of that limited partnership. And on the back, the Form LP5, completed by Pinsent Masons, which reports who are the company, the people who have contributed capital. And neither of them are Duddingston House Properties or Urbanist. Now, I'm not going to go into who they are now because I don't want to get a discussion. It should be dealt with in session 2. But the information that Mr. Steele put to his witness is not consistent with the only publicly available record for this entity on the Companies House website. And I think actually I might have mentioned one of them in my questions. Now, if it's not relevant, I don't understand why the question was asked. If it is relevant, then we should simply lodge this one-page document, which is the registration form for Carlton Hill LP, and its LP5, and then to the extent that it's necessary for you to know, you'll know that neither Duddington House Properties or Urbanist are partners. Now, of course, ultimately the reason I raised it was because I thought that the question had the potential to be misleading. And of course, I don't know what Mr. Steele knows, and he assures me he didn't know about this. So it's obviously no criticism is intended of Mr. Steele's actions, but it's more that I gained the impression that the question was not directly related to the publicly available information. And therefore, at this stage, I don't have a paper copy. Mr. Steele has my only copy. I have an electronic copy. I'm proposing to send a copy to Ms. Kerr just now, and perhaps suggest that once everybody's had a chance to read it and consider it, we might have a discussion at a quiet moment during the rest of this week about whether it should be received. And that would enable everyone to get proper instructions, and we want not, in a sense, to run the risk of things happening with a lack of information, which is what I'm trying to avoid.
That sounds fine. Is this something that we need to know about in order to properly advise ministers? Is it material to either the planning appeal or the listed building consent appeal?
It is only material to the extent that it relates to the weight that you, as reporters, and the ministers should give to whether Rosewood, in a sense, will turn up and do what they've said. Because if you are to rely on the assurances of an applicant or a site owner or a developer, you're perfectly entitled to take a view on that. But if, as we raise, there is a lack of information about this, and you want that information, you should have it, ideally from the appellant. And so it only relates to that. It's effectively the covenant of the Rosewood deal. Now, if, of course, your conclusion is ultimately that all that's being given permission for is a hotel, and that this, in a sense, is not relevant, then it all flies off and it doesn't become important, because a hotel is a hotel. It's a use classes order 7 use. But that's the only extent I say. It's not important in anything else. That's the only involvement.
So can I just clarify, I had not seen this document before the adjournment a few minutes ago, and the reason I hadn't seen it is because my learned friend hadn't drawn it to my attention. He still hasn't answered the question as to why he didn't lodge it timelessly, or why he didn't draw it to my attention to save exactly the fiasco that we're having now.
Okay. The suggestion is that there will be discussions. Sorry, Mr. Reeves.
Yeah. I mean, I think there's 2 points. The fundamental point is there's an appellant in these current proceedings, and we know who those parties are. There's also a party which has control of the site, and to some extent there might have been confusion as to exactly between the appellants and who has control of the site. The issue that I suspect all parties have been struggling with is there are elements of commercial confidentiality that have come into play, and at points that's been released and further information is provided. But Mr. Finney, who's going to come and speak at the economic session, is giving a professional view on risk, and he is giving you advice on these matters relative to the proposals. And I presume that the argument that's being deployed is it's okay, you can grant a luxury hotel development, and it is likely that it will proceed and therefore be able to provide a long-term maintenance of that hotel. The issue that he raises is that he's going to actually speak about these matters, and he talks about the developer and the risks associated with the developer's actions. And in that respect, his evidence does have information which is confidential. For example, he's had sight of the hotel management agreement with Rosewood Hotels and Extension, confidential. He's had sight of the pro forma projections, open brackets, confidential, Rosewood Hotels. Now, I don't think it would be improper to have asked him how the structure works for the overall deal if he's trying to give you the confidence that this may all come to pass at some point in the future. And I would have expected somebody of Mr. Finney's experience to have at least asked the basics of how this was to be delivered. And I think the way this has been brought out means that Mr. Finney has complete advance notice that those are questions that might be put to him in session 2. And I think before people make any judgments, there is absolutely no suggestion that the structures or anything are anything other than entirely appropriate and normal for a property transaction. So let's be absolutely clear, there's no suggestions that the fact that might involve funds in various parts of the world, that is in any way unusual, improper, etc. There are lots of funds placed all around the world that make investments into the UK property sector. So there's nothing suggestion that it's inappropriate at all. So I just want to make that clear. There's nothing on those lines, but it's just understanding how the structure of the developer works relative to the appellant is a perfectly reasonable question to have asked Mr. Finney. So all I'm saying is that I think the appellants may well have an opportunity between now and then to just state how they anticipate this all works and to give you the basic information, because it's their case that they're making on this particular point, not our case. So therefore, I think it would, as I say, this isn't trying to not give fair notice. I think the fact that it's been given now is probably better than waiting for economic session 2, where I think Mr. Finney could quite fairly have been asked questions about who is the developer, what's the structure, and I appreciate he's not going to be able to tell us who the non-binding term sheet from a renowned bank would be, but he would probably have to ask certain questions about that without revealing certain of the detail, because obviously certain aspects wouldn't be confidential. So, as I say, that's where I come from on this. I don't think there's anything that shouldn't be capable of being resolved relatively simply by Mr. Finney at least having an understanding of the structures that are involved.
Mr. McIntosh, do you say you wish to request to have this document lodged now, or do you wish to have further discussions with Mr. Steele before doing that?
What I think would be the sort of calmest and least disruptive thing to do is that I've sent it to Ms. Kerr just now. It'll be sent to you, so you'll see what it is.
I'm anxious not to see it before.
No, that's just unacceptable.
I will make sure that a message goes to Mrs. Kerr not to transmit that to us.
Okay, well, my misunderstanding. Ultimately, I'd assumed that you would want to know what it is we're talking about before you decide whether to receive it. But
so that's just wholly unacceptable. Firstly, Council should not be communicating with the Office, and secondly, my learned friend should not be submitting a document which has not been received yet to your Office. It's just wholly unacceptable to have done that.
Firstly, I'm directly instructed, and therefore I'm unable to communicate with the Office by any other means. And secondly, I don't want the matter of whether this document is to be lodged to be dealt with today, because I think everyone needs to think about it calmly. And I want to emphasise that the only reason I've suggested it be lodged is because I was concerned about accuracy. And
so can I suggest to diffuse this, sir, that we defer this matter for a little while, and it will have to be. Yes, I'm just reminded, of course, if that document has been received in your office, there may be an obligation to put it on the website. I mean, it is just, frankly, outrageous for my learned friend to have sent that in.
We will make sure that, one, we don't see that until we've agreed to accept it, and two, that it won't be published.
Well, I'm grateful for that, sir.
I appreciate...
Can we defer? I wonder if I can finish, please. I wonder, sir, if we could just defer this matter, and we will take proper instructions and consider the matter. And as I had indicated earlier, we should be able to deal with this if it's an issue at all, which I submit it's not, during the economic session, which is a week or two away.
Perhaps it's just worth observing, it's a public document that I obtained publicly. It is published. and therefore I can't see anything other than the issue, which I respect the tribunal's, the inquiry's own procedure, that I can't see any issue with it being publicly available. Anybody can obtain it. But I think it should be dealt with later on. And what I was going to suggest is once everyone's had an opportunity to reflect, we pick this up towards the end of next week when we can see the start of session 2 is in mind. And perhaps we could all reflect on Mr. Innes's comments about whether these issues could be raised with other witnesses.
I think that's right. It's not an inquiry document for the moment, albeit that we appreciate you say it's a public document. And we will make sure we don't see it nor publish it, and we'll wait to hear from the parties on whether that is to become a document, perhaps with other documents and or an additional witness. Okay. Anything else? Ms. Coburn.
Yes, I do. I'm assuming, Mr. Steele, have you finished your re-examination of Mr. Mappin, yes?
Yes, I've rather forgotten about that, but yes, I have indeed. Thank you.
Okay. You'll recall, sir, during the re-examination by Mr. Steele of Mr. Wright about the very serious allegations that Mr. Wright made about our client. I wonder if Mr. Steele could assist, because obviously Mr. Drummond has very limited availability. And the material being contemplated, at least by Mr. Steele, if not by Mr. Wright, in that re-examination. Could Mr. Steele confirm if he intends to cross-examine on the basis of that information, and if so, who he is going to cross-examine?
Actually, I can't at the moment because my mind's in other matters and I haven't even thought about that. I'm sorry, I can't assist at this moment. I'm happy to have a discussion off stage about it.
Well, that would be very helpful, because obviously, given Mr. Drummond's availability and given that the questions would properly have to go to Mr. Drummond, I would need to recall Mr. Drummond as a witness if Mr. Steele intends to cross-examine. Because, to be clear, sir, the document being contemplated by Mr. Steele, if not by Mr. Wright, in Mr. Steele's re-examination, was not a document that was produced by our client. It was produced by somebody else who's a party to the inquiry and who follows on after us. So the concern that I have is if cross-examination was to be put, I would need to have my witness come back to speak about it. And given Mr. Drummond's availability, ceases at 5 o'clock, essentially turns into a pumpkin at 5 o'clock on the 11th, I would be grateful if we could have some clarity sooner rather than later. And that's all really I want to see at this time.
Okay, you will discuss that with Ms. Coburn. Mr. Stinks. Okay, perfect. Anything else?
Yes, there's I suppose formally before the appellant closed their case, Mr. Gibb, during cross-examination from me, was left with some homework, and that related to lift shafts and the change of building regulations, and whether the 2015 scheme as drawn would comply with the new building regulations. Don't seek an answer now, but it's just a reminder at some point that we might need some Mr. Gibbs clarification, and I think in a similar vein to what's been sought in terms of the references to conservation areas, I'm more than happy if it's a short note from Mr. Gibb submitted rather than wasting inquiry time. But if we could have clarification of that particular point, I don't want to leave that outstanding forever.
Okay, I must admit I'd lost sight of that one, Mr. Innes. Mr. Steele.
So had I, sir. But we'll discuss it.
Okay, great. Anything else? Okay, so we are moving on to have the council's evidence. Best to do that after lunch. I would have thought, to give you time to get yourself organised, Mr.
Sounds a very good idea, sir.
Perfect.
Thank you.
Okay, let's break for lunch until 1:50. Hear the start of the council's evidence in session 1. Just before we do that, I've realised just recently that Mr. Leslie and I worked for the same employer, shockingly, something like 35 years ago or something like that. I don't consider that has any implications for how I deal with the case, but I just wanted to draw that to the party's attention.
certainly no difficulty from our point of view.
Thanks. Anything that we need to discuss before moving on to take the Council's evidence? No. Mr Thompson.
Thank you, sir. Good afternoon, Mr Leslie. I think that you have before you your precognition and your rebuttal precognition. You don't have an inquiry report, so it's just these two documents that constitute your evidence for the inquiry.
Correct.
And I think that you're David Leslie, you're the Chief Planning Officer with the City of Edinburgh Council. I think we see from paragraphs 1.1 and 1.2 your role and your qualifications and your honour. Could I ask you to start reading, please, at 1.3 in your precognition?
Thank you. I have continuous local government service in planning and related services since 1984 and have held various senior management roles within the Council since 1996. I was acting head of planning and building standards from October 2012 to November 2015. Since January 2017, I have been Chief Planning Officer. In both of these roles, I have been the Council's lead professional planning advisor.
And could I just ask you there, please, what was your role between November 2015 and January 2017?
During these dates, there was a service restructuring, and my role was as service manager in charge of citywide planning and transport policy and strategy issues.
And does that mean that you had no involvement in development control during that period?
That's correct. I had no line management responsibility nor proper officer role during that time.
Thank you. Could I ask you then, please, to start reading the substance of your precognition, please, at paragraph 2.4.
As the workshops progressed, I held a number of liaison meetings with the development team and separately with the planning team and consultees to try to target the workshop discussions, progress actions and make meaningful progress. We expressed the desire to consider a range of options, not just the iteration of one preferred approach by the development team. It was clear that despite extending the workshop series, we did not have a consensus on key planning issues when reporting back to Sue Bruce, the Council's Chief Executive, on this innovative workshop approach and its findings prior to the formal planning pre-application process commencing. The review workshop identified a number of issues for further review prior to the formal planning pre-application process commencing. Following completion of the initial workshop series, I issued a refreshed planning advice letter to the development team on the 12th of November 2014. A timetable for the pre-application process was initially proposed by the development team, commencing in November 2014 and running until February 2015, after which the planning applications would be submitted. I expressed my desire to have a planning processing agreement in place as early as possible to manage expectations about timescale to determination. The handling process for major applications. There are statutory requirements for pre-application consultation with stakeholders where a development is classed as major in terms of planning regulations. The Council has worked with the development industry and community councils to make best use of this period in building awareness and understanding of proposals and the issues raised by them. The process that the Council Planning recommended to developers is set out in the Edinburgh Planning Concordat of 2013. I consider that the exercise to build awareness and understanding in workshops at the feasibility stage of these proposals was compatible with principles of the Concordat. However, they only involved the Planning Authority and statutory consultees. They did not involve wider community engagement as recommended in the Edinburgh Planning Concordat. The agendas for the workshops were largely set by the developer, whereas pre-application meetings would normally be arranged by the Planning Authority and would focus on Council planning identified issues. This is to assist in the submission of an application which is supported by relevant information and addresses issues of Council planning policy and guidance.
I wonder if I could ask you there just to move on, please. Take the next few paragraphs as read and resume reading at 3.7, please.
Paragraph 3.7. The Council's Planning Committee seeks to promote a high quality of urban design. In 2009, it established the Edinburgh Urban Design Panel as one of a range of measures to raise both the quality of the built environment and the profile of design in Edinburgh. The panel consists of a series of independent experts nominated by the 11 membership organisations of the panel, which include Architecture and Design Scotland, the Coburn Association, the Edinburgh Architectural Association, Historic Environment Scotland and Edinburgh World Heritage, who have a particular expertise to offer to the development teams at the pre-application stage of preparation of development proposals. The panel reviewed and provided its advice on 2 sets of proposals at this stage in May 2015 and November 2016, respectively. The panel meets once per month and generally reviews 2 development proposals at each meeting. Its limited time for review means that certain types of development proposals are more suited to the more extensive design forum workshop approach offered by Architecture and Design Scotland. The panel's operating procedures identify that locally significant developments, that's Architecture and Design Scotland's definition, which are assessed through the design forum approach, will not be reviewed by the panel. However, in a very limited number of cases, exceptions have been made where both the panel and the developer have recognised benefit in having an additional contribution from the panel to the design process. An exception was made in the case of these applications. The sign-off process for reports of handling. Reports prepared for the Development Management Subcommittee are edited by 2 team managers following submission of the draft report by the case officer, in this case 2 reports by 2 planning case officers. The edit process aims to ensure that a robust assessment of planning policies and guidance has been carried out, that the recommendation is supported by coherent professional planning judgment, and that the report contains the necessary information for members to understand the proposals and the issues raised by consultees and in other representations. Then, after the report has been edited and any changes made by the case officer, it is presented to the proper officer, who has delegated powers to determine applications and to make professional planning recommendations to the subcommittee. In 2015, that officer was the head of Planning and Building Standards Service until November, when after management restructuring it became the head of Planning and Transport Service. The role of the head of service was to ensure that he accepted the assessment and the recommendation and to sign off the report for inclusion in the subcommittee agenda papers. The sign-off of the 2 reports of handling to the Development Management Subcommittee meeting of 17th of December 2015 followed this process. While I had a role in the editing of the reports, the final sign-off was by John Burry in the proper role of head of service. Similarly, the sign-off of the 2 reports of handling to the Development Management Subcommittee meeting of 31st August 2017 followed this process. The final sign-off was done by myself in the proper officer role of Chief Planning Officer. In conclusion, I am of the opinion that the Planning Service provided consistent and helpful advice at the early stages of preparation of the development proposals and that due process was followed in the handling of the applications.
Thank you, Mr. Leslie. I wonder, could I ask you now to look at your rebuttal recognition, and could I ask you to read paragraph 2.3, or to start reading at 2.3.
Okay, Andrew Wright recognition. Paragraph 2.3. Paragraph 28 states in conclusion that the outputs of the workshops of 2014 assisted in the evolution of the design. I agree that the workshops assisted all participants at the informal pre-application stage in the understanding of some key issues. However, I rebut the suggestion that by having careful regard to the outputs of the workshops, the design of the proposals would be acceptable. There were additional planning issues which needed to be considered. My letter of 12th of November 2014 set out issues which had been consistently raised by planning officers but had not been addressed during the workshops. Gary Mappin recognition. Paragraph 1.12 describes the revised hotel proposal as substantially reduced in scale, and the appellant's perception that the Council displayed little enthusiasm and a hardening of opposition in the pre-application stage for the revised proposals. I rebut that on the basis that the revised proposals were considered on their own merits and afforded the correct level of assessment. However, as stated in above paragraph 2.1, the extent of engagement relates to the complexity of planning issues arising from development proposals. The advice for and assessment of revised proposals for any development will have a different starting point in terms of all stakeholders' understanding of planning policies and site-specific considerations. I would expect there to be a variation in the time and resources used to assess revised proposals, but that does not imply inadequate assessment. Paragraph 2.15 is factually incorrect in referring to 50 years of vacancy and neglect. I personally visited the Principal Hamilton Building for weekly corporate project team meetings in the early 2000s, when a variety of council services occupied office space prior to the construction of Waverley Court. Gordon Gibb recognition. Paragraph 21 refers to patently stronger objections to Scheme 2 from the Council. I have already rebutted the suggestion of little enthusiasm and a hardening of opposition in paragraph 3.1 above. The allegation of stronger objection must be viewed in the context of differently constituted council after the May 2017 election and a different set of elected members forming the Development Management Subcommittee. Members of that subcommittee make their individual decisions based on the evidence in front of them and the weight to be afforded to the material planning considerations.
I wonder if I could just interrupt you there, Ms. Leslie, and ask you if you could elaborate slightly on the point about the differently constituted council subcommittee.
Following the May 2012 election, the Council's governance arrangements were changed, and the Planning Committee and the Development Management Subcommittee, which have the same membership base, were reduced in number from 15 members to 11 members, consistent with other council committees. The membership of those committees was significantly different following the election. A significant number of new members elected to council, and I have checked back that there are only 3 of the 11 members who were previously on the committee prior to that election.
Sorry, so there have been 3 of the 15 at the 2015 meeting and 3 of the 11 on the consideration of the Scheme 2.
That's correct.
And where did consideration of the trust proposal come in this timeline?
The consideration of the trust proposals were in August 2016, which was prior to the election. So it was the same Development Management Subcommittee that had considered the first proposals in December 2015.
Thank you, Mr. Leslie. Could I ask you then to resume and simply read paragraph 5.1?
Gordon Murray precognition. Paragraphs 4.8 and 4.9 set out an interpretation of the role of the Statutory Approvals Service. I agree that a local authority planning service should work in a professional manner with the architect of any development proposal. However, I rebut the suggestion of obligation by the planning authority to endorse a proposal from a developer who has entered into a property contract with a local authority as property owner. It is fundamental to the integrity of the planning process that a professional planning assessment of development proposals is not fettered by other interests of a local authority. The Council operates a clear separation of such interests, both at elected member and planning officer levels.
And I think we can take your rebuttal of Mr. Collins as read, as we've done with his recognition. So thank you very much, Mr. Leslie. Thank you, sirs.
Thank you, Mr. Thompson. Mr. Steele.
Mr. Leslie, good afternoon to you. I'm going to try and take matters fairly swiftly this afternoon in the hope with finishing this afternoon. So if I'm going too quickly or you don't understand me, please let me know. Mr. Leslie, You approve of demolition of A-listed buildings on Carlton Hill, do you not?
I'm sorry, Ed, can you clarify the question for me? Which buildings?
Well, I'll come to the precise detail in a moment, but is it fair to say that you are approving of the demolition of A-listed buildings on Carlton Hill?
I'm not clear of which application you're referring to. Out of context, that's a difficult question to answer.
Do you also approve of the erection of a new modern architecture with a patinated brass or copper roof on Carlton Hill?
I think you're referring to a proposal in the City Observatory.
Indeed I am.
Correct. The application was approved. I think if you ask me out of context of the wider consideration of that application, which I don't have the report in front of me, it's difficult to isolate one particular feature of a development.
Well, that's very fair, Mr Leslie, but your name is on that report, so I take it my question is correct, that you did approve of the demolition of 3 A-listed structures and the erection of a new modern architecture building with brass and copper, patinated copper on Carlton Hill, did you not?
I agreed with the assessment and the recommendation of the whole application.
Indeed. And was that a proposal that involved the erection of the modern architecture on the apex of the hill, with on the skyline and with clear views of it from many miles around?
I'm aware of the location of the development. Again, without the report in front of me, I cannot be certain that the summary that you've given is indeed compatible with the assessment in the report.
Do you know the location and know the building I'm talking about?
I am aware of the building you're talking about, yes.
And can we agree that it is on the skyline and would be prominent from a significant number of locations?
I am aware that the building sits on the top of the hill. In terms of its prominence and view from different locations, again, I would have to refer to the assessment of that application and the factors taken into account.
Do you know whether there was a significant amount of glass on that new building?
I don't recall the detail of the development.
If I may put this to you, Mr Leslie, the proposed development, although bold in concept, will enhance the City Observatory compound, and if I can just put that in brackets just now, providing an exciting new landmark building on the skyline. The development represents an improvement of an area of dereliction in Carlton Hill, and the aims of the project are in keeping with the aspirations of the Council for Carlton Hill.
Mr Steele, is this a document that's before us?
No, it's not, sir. If the witness, I have copies here, if the witness is at a disadvantage, she can say so. The point really is a simple one. And in particular, this sentence, Mr Leslie, it will ensure public access, disabled persons access, and a commercial use for the site which will be sustainable. Is it fair to say that almost all of that could equally apply to our proposal?
I'm listening to your quotation from the report. I don't have it in front of me, but I think the scale of development and the location of the development relative to the hill are different considerations. If I'm going to elaborate on that, I would need to have the report in front of me and see the wider assessment issues.
That's very fair. If you or Mr Thompson wish to see that, I have it here together with copies if necessary. But can we agree this, that insofar as that ensured public access, we would also ensure public access, disabled person access and a commercial use for the site which would be sustainable.
Sir, before that question is answered, it's not just a question of the Council's interest in this. There are other parties to this inquiry who also don't have access to these documents. And maybe you want to revisit the position, sir.
Mr Thompson.
Sir, Mullen Friend is entitled to pursue lines of cross-examination that he wants. If he's going to make anything substantial of it, standing Mr Leslie's position that he doesn't have the report in front of him, I would question the validity or the practical use of any evidence that is taken in that way. If the matter is to be pursued and a comparison made, then fairness would require the document to be produced and for all parties to consider it. And you might take the view that it's a bit late to be doing it now.
I think I agree with Mr Thompson. I mean, there's a limit to what we can take from this. We have no way of verifying any of this.
Indeed, sir. I have got the document here, plus sufficient copies if people would like it, if you would find that helpful, sir. I had 2 more questions about this matter, and then was going to pass on to another topic altogether.
Not another development that we don't have the committee report for?
Not yet, sir, no.
Mm-hmm. Mr Thompson, do you wish to see that document being lodged or not?
So it very much depends on what my learned friend wants to make of it. At the moment, you've heard evidence from Mr Leslie without the report in front of him. In my submission, that's worth considerably less than it would be if he'd had a chance to consider it and all parties had had a chance to make observations on it. If my learned friend wishes to proceed in that way, that's up to him.
Mr Steele.
Sir, I'm happy to proceed either way, to be honest, sir. If you'd like to see the report and Mr Leslie would like to see the report, I'm delighted to do that. Equally, I'm perfectly happy to proceed without it.
I must admit I'd prefer not to be taking late documents right before cross-examination. Mr Leslie, if you feel you can't comment without having seen the documents, as you've already done, feel free to say so.
Mr Leslie, just on this point, just 2 further points. Can we agree then that there has been a change, possibly significant change on Carlton Hill as a result of this approval, and I think we can see the building work ongoing on the hilltop at the moment?
Any development involves some change. I'm not sure that I would use the word significant in the way that you are.
But if anyone suggests there's no change on the hill, that would be factually
Sir, before
inaccurate.
this question is answered, I have a concern about where this line is going also. I don't recall any of the witnesses from the appellants mentioning or placing any reliance to any great extent on the issue of other developments having brought about a change in the landscape on Carlton Hill. Maybe I'm not putting that entirely correctly, but there is a concern that a line's being opened up which was not part of the appellant's own case and their own evidence.
I think I can recall some evidence being laid on change over time on Carlton Hill. So I'm happy for Mr Steele to finish his question or 2 that's remaining on this issue.
Just on that then, can we agree, Mr Leslie, whether it's significant or not is a matter of judgment, but it cannot be suggested there's been no change on Carlton Hill as a result of this development alone, apart from any other considerations. Would that be fair?
Development progressing does imply change, yes.
And secondly, can we also agree that even if there are issues of prominence and skylighting, they may, in appropriate circumstances, be outweighed by other planning considerations, such as reuse of the building and commercial use and the like?
In a general sense, that is part of the planning assessment of a proposal, yes.
And in truth, that's really why we're here.
Yes.
Now, can I take us back in time a little bit, Mr Leslie? The reasons for which will become clear shortly. Can I take you to CD 439? And I'd like to take this all fairly briefly if we can. I don't think it's a matter of any dispute. And if it is, no doubt others will say. Does that constitute the notice details as we'll see, about two-thirds of the way down in relation to the competitive dialogue in relation to this site. A number of years ago, and I've now lost the date, I'm afraid, but perhaps you can assist me with that.
I was not a party to the contractual arrangements, so I'm not familiar with these documents.
Right. Sorry, I thought you would be aware of it. Well, if we go to two-thirds of the way down, do we see that there was a public notice contract placed by the City of Edinburgh Council wishing to enter into the competitive dialogue for the site in question to propose, develop and deliver a sustainable and robust commercial business solution for the business for the building, at the Royal High School, and development to be non-residential real estate. You see that?
Yes, I see that paragraph.
And if I can take you a couple of documents further on to document 440, a document dated March 2009, do we see at 2.4 that the running costs at that time were £250,000 a year to ensure wind and watertight, but not being sufficient to meet the costs of structural repairs. You see that?
I see that paragraph, yes.
And at 2.6, is it stated that for nearly 9 years, the Hill Adamson Trust had been exploring funding sources to secure the future of the Royal High School for the National Photographic Centre?
I think that is correct, yes.
And do you recollect, I don't think it's stated here, but do you recollect that that was fronted, I think, by Sean Connery at the time? Is that so? Have I got that right? Do you recollect that?
I don't recall that level of detail about the proposal.
And if we then go on to 3.12, do we see that the Council had been exploring other possible uses, and the most likely use appeared at that time to be for entertainment, boutique hotel, etc. We can read what it says for ourselves. Is that fair?
That is correct.
Yeah. And the proposal was, at 313, for an open market competition to attract potential developers to develop the site in the way anticipated by the Council. Is that a fair,
yes,
brief summary? Again, I don't think this is controversial. So the recommendation to committee is to note that there was no realistic prospect of the photographic centre progressing through lack of funding. Is that correct?
That's not something I can comment on from a planning perspective. I didn't have any involvement in the writing of this report or the assessment of an alternative use of the building at that point.
Well, is that not what 7.1a says? No realistic prospect?
That is what the report says, but I have no opinion on whether that is correct or not.
Well, Mr Leslie, I don't think for a second that a council official would make a recommendation to a committee unless it was factually accurate. Do you?
I'm not doubting whether this was accurate from the manager. You're asking my opinion of whether I agree that there was no realistic prospect. I don't have a view on that.
It was the view of whatever official wrote this that was the case. Is that not so?
I agree that the author of the report was the manager of property management and development. That would have been his opinion, yes.
And if we go to 442, a report of 16th of March 2010, could you read out paragraph 6, please?
On 2nd of February 2010, the selection panel confirmed Duddingston House Properties as the preferred partner to deliver a sustainable development and business solution for the former Royal High School. Their proposal foresees the transformation of the former school into a 6-star arts hotel with a high-quality design which will combine gallery space with hotel accommodation and a first-class restaurant. The proposals encourage public access, community engagement, and will enhance pedestrian flows to Calton Hill.
And for completeness, could you read out paragraph 7, please?
To ensure the integrity of the competitive dialogue process, all proposals comply with the Block 10 String of Pearls development brief approved at Planning Committee on 15th of May 2008. Other selection criteria included the contribution to Edinburgh's offer as a tourism destination, project deliverability, functionality, the appropriate use for an iconic building, and commercial potential.
And as I understand it, Mr Leslie, you did not write this report and may not be aware of it. Is that correct?
I may well have been aware of it at the time, but I certainly didn't write the report.
No. And whoever wrote the report and whatever committee did or did not endorse it, the terms at paragraph 6 and 7 are self-explanatory, are they not?
Yes, they are.
And so there can be no doubt that at that time, the view of the author and the relevant committee is that our proposal, by which I mean my client's proposal, complied with Block 10 String of Pearls development brief. That's what it says, isn't it?
Yes, that is a development brief approved by Planning Committee.
Thank you.
I wonder if there's a meeting of minds between my learned friend and Mr Leslie on those questions. The particular point is that it was suggested that there was an agreement by the relevant committee in addition to the author of the report. And my recollection was that that report was put up for noting rather than anything else, in which case it may not be fair to take endorsement of the committee from that. But I stand to be corrected. I don't have it in front of me.
Well, Mr Leslie, do you have an understanding of what happened, or will I take you to the next document?
I'm sorry, could you elaborate on what you mean by what happened?
I think the suggestion by learned friend Mr Thompson is a question as to whether this was a committee decision or endorsement or not, if I've understood the matter correctly. And for fear of leading, and Leonard Frank can stop me if I want, is the answer to that to be found in...
I think it's paragraph 11.
Pardon?
Paragraph 11, I think.
Yeah, paragraph 11, that the committee noted the contents of the report. What does that mean? Does that mean the committee agree or disagree with the contents?
In normal business of council committees, if a committee is asked to note something, it's not making a decision, it's further information.
Thank you. But what we can agree, I trust, is that so far as the relevant department or departments were concerned, the position is as expressly set out at paragraph 7.
It is factually correct that the development brief referred to there, which had been approved by Planning Committee, was a basis for criteria in that dialogue.
And what it says is that all proposals, which clearly included the Duddingston House one, complied with Block 10. Isn't that correct? I accept that fully, but that's what the document says. Yeah, well, we both have to. I wasn't involved either.
Yes.
Right.
Mr. Steele, I may have misheard. I'd be grateful if you could help me out. Someone mentioned this was a planning committee report. This is 442. I read it as a finance and resources committee report. Did I mishear?
Headed up finance and resources.
I'm obliged.
I don't recollect referring to planning.
I think I may have referred to Planning Committee when I was referring to the development brief which was approved at Planning Committee in May 2008.
Which is what's correctly stated at paragraph 7, Mr Leslie, isn't it? Yeah. I think you and I are at one, at least on this matter, so far.
On that fact, correct.
Yes. Long may it continue, Mr Leslie, and we'll speed through this. Now, Appendix 1, paragraph 4, it discloses that there's to be a lease for 125 years on a full FRI basis. Does it not?
That is what the report says, yes.
And paragraph 10 required the council, other way around, required the developer to demonstrate to the council that it has the adequate and necessary level of funding.
So just before Mr Leslie answers that, I'm just mildly concerned that we're getting well into one of the two embargoed areas for inquiry session 1, which are the development brief for the site and the selection of the preferred developer. I resisted objecting before because my learned friend may be entitled to dip into those documents and extract pieces of relevant information, and I don't object to that. But I just put down a marker that, as far as I was aware, this was an embargoed area that we weren't looking at this inquiry. And if that embargo is to be ignored, then it will have consequences.
So I wasn't intending to, nor aware that I had gone into an embargoed area. Of necessity, one will, en passant, refer to matters, but I didn't go into the question of the development brief. I didn't ask a question about it. So far as selection is concerned, it's a matter of fact that we were selected. I'm not wishing to delve into that, and I'm hoping to speed through this as rapidly as I can, but it's part of the background, sir. Firstly, and secondly, there is an important point that I'm coming to as soon as I can get there in a few minutes, which is important in my submission to the planning considerations.
That's fine. There is something in what Mr Thompson says, and there's a limit to what we can gain from Mr Leslie agreeing to things that he's reading but that he's had no real involvement in. But if you're coming to something more material, that would be good.
Indeed, sir. Thank you. Now, paragraph 10, the council, the developer required to confirm its funding arrangements. Is that correct, Mr Leslie?
Again, I'm reading the report. I have no reason to doubt that.
Were you not aware of that? Because that may have been an important planning consideration at a later stage.
I was not involved in any of these contractual discussions. I wasn't present at these committee meetings where these matters were being discussed.
And at 22, I don't know if you're aware of this, that the council was retaining some element of control over the site by virtue of the fact not allowing assignation. Were you aware of that?
No, I wasn't.
And as a landlord, the council is perfectly entitled to do that, maintain control over the site as to who may or may not be the eventual operator or occupier. That's what they're trying to control there. Would that be fair?
I'm not an expert on property matters and I haven't been involved in the details of that, so I can't comment one way or the other.
And just for completeness on this, at 443, page 9, do we see that Duddingston House on the 16th of March 2010, this is confirmation that the committee had already approved Duddingston House as the preferred partner at 19. And I just mentioned that. I'm not going into the detail of that, but that's factually accurate, is it not?
It's in the minute of our meeting. Yes, it must be.
Now, at 444, if we turn the page, at paragraph 5, do we see there the minimum number of bedrooms that was set at 120?
Yes, I recognise that figure.
And are you aware of whether that figure came from the council or not?
Planning Service didn't have any involvement in the discussion at that stage of the size of hotel, so I was not directly involved in in discussions that led to that figure.
No, but are you aware that it was the Council, I'm not really too troubled which department it was, but it was the Council that suggested a minimum figure of 120?
In terms of information provided to me at the beginning of this process, my understanding was that the figure was reached in relation to the definition, a minimum in terms of a definition of quality.
That's very, very helpful indeed. Because I was going to come on to that, Mr. Leslie. Why do you say the figure of 120 was arrived at, and why do you say it was a definition of quality? Can you elaborate upon that, please, from your understanding of the matter?
Yes, I'm going back to one of the references that you led me to earlier on, which talked about a boutique hotel, some terminology of that nature. My understanding was that there was a desire on the property side to try to quantify that. But I must emphasise that the planning service wasn't involved at that stage in that discussion.
Right, I've got that, Mr. Leslie, but from you, within the Council, if I can keep it as neutrally as that, there was a desire to have at least 120 bedrooms to ensure that there would be suitable quality from the hotel operation. Is that correct?
I think I would agree with you. There was a desire from the Council to deliver a quality hotel, and the size in terms of bedrooms was a proxy for that.
Yes. And was the fear that if there was something much smaller than 120 bedrooms, the necessary international type operator would not be attracted? Was that the fear from within the Council?
I believe that was a consideration for those who were negotiating the contract.
When you say those that were negotiating the contract, I want to be quite clear about this, those who were negotiating the contract from within the Council. Is that
correct?
Correct. And I'm not suggesting it was you, Mr. Leslie, but I'm merely trying to test your knowledge. So we're in agreement that it was the Council, whichever department, I'm not interested in, it's the Council that wanted at least 120 bedrooms to ensure, so far as humanly possible, that there would be a quality type operation.
From my understanding, that, as I say, the figure that was put against the number of bedrooms was a proxy for a quality hotel.
Yeah, that was one way of trying to achieve it.
Correct.
And for anyone that's concerned about the lack of knowledge about 120 bedrooms, may I take it that this minute or item or agenda, whatever it may be called, has been publicly available since on or about the 1st of November 2011?
It is a publicly available committee report.
I raise that with you because others are making a complaint that they didn't know that it was a minimum of 120 until very recently, but in fact, has that been public information since 2011?
Correct.
In terms of the, and I'm not going into the details of the competition, but can you identify for me, for my benefit, who were the judge and jury in relation to the competition? Were there any, how many were those officials of the council or councillors?
I hesitate to interrupt Mr. Steele again, as I recognise I may be annoying him, but this does seem to fall within the topic of the development brief for the site and the selection of the preferred developer. And I'm relatively sure, other than the observation that the late Professor Charles McKean can't speak for himself, the topic hasn't been touched on so far. And I do wonder whether we're going well into the area of that you had indicated you didn't want to hear about.
So that's a little bit rich, given that Mr. McIntosh has asked us about Charles McKean and his notes and the like. And all I can say, sir, is that his constant interventions are actually taking longer than it would take me to ask the question. I'm not going into the detail of all of this, but I'm trying to establish what the position was without in any way, I hope, offending your embargo. And I haven't even asked the question yet.
We did say in the procedure notices that we didn't wish to hear about the competition. And I accept that we have heard bits about it, Professor McKean's notes and such like. Are you going much further with it?
No, sir. I've got 2 or 3 questions on the matter. I'd just like to have confirmation, apart from Mr McKean, who we've heard a lot about, who else was on the panel?
Okay.
That's the first point, and there's a consequential one. Can you tell us that, Mr Leslie, who else was on the selection panel?
Sorry, I don't have that information.
Well, that's helpful. Could you look, please, at our inquiry report by Mr. I'm just assuming that's not a fire alarm of sorts, sir.
Doesn't sound like it. Sounds like some sort of building operation again. If it worsens, I think we're going to need a break, but try continuing for a minute.
I'm happy to continue. Could you look, please, Mr Leslie, at Gordon Gibbs' inquiry report, which is our APP 4141. And if you go to page 7 of that, you will see 2 concept sketches. Now, do you know or do you realise that those are the sketches that won the competition? And there's a particular purpose for asking you about that, Mr Leslie. Those are, to be fair, something very, very close to it.
I can't say for certain that that is exactly what won the competition, but I do generally recognise the sketch.
That's very fair. And again, I'm not going into the detail of this, but can we agree that there are 2 blocks, one on either side of the main building and situated quite close to the main building, and a number of...
I'm sorry, Mr Steele, we're finding it difficult to hear now. Can you bear with us?
We'll do it. We'll do it. So, should we have a break for a few minutes? Is that the...
It needs to be here if we make a start. I think so. We've got a message to the venue, and they're working on that. Well, not working on that, but working on having the noise stopped at the minute. So let's try to continue. Mr Steele, sorry.
Thank you, sir. Mr Leslie, I think the question I was asking you was this in relation to the competition, whether that represented what you understood had won the competition, namely 2 blocks, one on either side of the main building and a number of stories high. The precise number of stories difficult to judge, but clearly of similar height or perhaps slightly taller than the main Hamilton building. And I think you're about to answer that, or had started to answer that, when we had to stop.
Yes, in a general sense, that is familiar in that it is either the same or similar to that which I saw at an early stage of the beginning of the dialogue with the developer.
And I think at or about that stage that you became yourself personally involved in the dialogue, is that right?
The date that you're referring to is 2010 on this diagram?
Yes. Well, it is on the diagram. That is so.
I've stated in my precognition that it was November 2012 that I first met the development team.
That is so, but you were involved with the dialogue that took place after your involvement.
Yes, from 2012 I was involved in some dialogue from a planning perspective that didn't really take any meaningful progress until the beginning of 2014.
Right. Well, we'll look at that just in a moment, but could I just, before we do that, could I just ask you please to look at document CD 498. And I stress I'm not going to get into the detail of this, Mr Leslie, but just one or two questions at this stage, because with you I'm just going to try and take matters briefly at a higher level. Page 34, paragraph 3.42, D. Now, if we ignore the first few words, but it continues, that it has been marketed at a price reflecting its location and condition to potential restoring purchasers for a reasonable period. May I take it that we can easily agree between us that that was done because you had marketed it, not worldwide perhaps, but Europe-wide, obviously for a reasonable period of time, to all sorts of purchasers, including obviously potential restoring purchasers? That's the site we're talking about.
If you're, excuse me, if you're asking in relation to the role of the competition in that, then yes.
Indeed I am. And so far as the economic part of D is concerned, I simply leave that to the later stages of the inquiry, session 2. So I'm not asking you about that, but we can agree that so far as the latter part of D is concerned, that has been complied with in terms of the advert for the competition and so on and so forth.
I think you're reading the second part of paragraph D and not the first part.
Indeed, I'm deliberately not reading the first part because that's for another session at the inquiry, and I'm only asking you to confirm that from the words that it has been marketed, that to the end has been complied with.
It was marketed through a competition, yes.
I would suggest that's the end of the matter, but I'm taking it in stages. Mr Leslie, I'd now like to turn to see what advice was given to my clients, I think largely by you yourself. Could we look firstly at CD 378? My apologies, this actually is from Mr Burry, but in any event, if I can put it to you. That was a letter within 378, Appendix 4, dated July 2010. Do you have that, Mr Leslie?
I do, yes.
Yeah. And there's a doubt Mr Burry is obviously within the planning department. Indeed, he's the head.
Correct.
Yeah. Head of planning. And do we see in the second paragraph that the hotel use was supported by the local plan policy?
The principle of a hotel use is supported by the local development plan.
Although, taking the matter briefly, details needs to be discussed and agreed.
Yes.
Was it also stated that the importance of the site was clearly recognised and understood, presumably by both parties at that time, 2010?
Yes.
And if we look at page 2, under the heading demolition, etc., do we see that the Council, very reasonably and properly, was willing, indeed possibly wishing, to work with the architects as much as possible to facilitate the development of the hotel?
Correct.
And in terms of the heading extension, was it the view of the head of planning that there was scope for the new development within the site, subject to accepting the demolition primarily of the gymnasium building?
Correct.
And at page 3, second paragraph, the following is said: the proposed extensions are symmetrical in their approach, thereby adding to the composition of the building itself. What do you understand that means, Mr Leslie?
I think that's referring to the diagram that you brought to my attention a few minutes ago in terms of the proposals in the competition-winning design.
And do you think that was an issue of support or flagging up a concern at that time? Which way do you read that?
Well, the next sentence says it is questioned whether this is the correct approach. So I don't think that the sentence that you're referring to is in any way an endorsement in this letter by the Planning Service.
And that was referring, as you've correctly said, to the two symmetrical blocks that were on the table at that time. Yeah. Now, for ease of reference, although it's out of date chronologically, could we look at the next letter, 12th of November 2014? As I say, I'm jumping about a bit in time, and we'll go back. But this is a letter, I think, from you. Isn't that so?
That's correct. That's the letter that was issued following the completion of a series of 5 workshop discussions.
Sorry, clearly in a fair reading, it's a letter that's designed to be helpful and make progress. Would that be so?
That was the intention.
Under the heading Appraisal of Proposals, Demolition of Buildings, you say this: our previous advice stands in regard to planning policies supporting the demolition of the gymnasium building and the later single-storey blocks in the plural. Could you tell me which the later single-storey blocks in plural were that you were referring to?
I'm sorry, without a site diagram and reference to the workshop notes, it's difficult for me to remember exactly which blocks were referred to in this letter.
Well, I can do that if necessary, Mr. Leslie, but you must be familiar enough with the site to know how many blocks there are and how many are single-storey, out with the main Hamilton building, surely.
My recollection is this is talking about the area to the east of the Hamilton building where the gymnasium is located.
Well, it says supporting the demolition of the gymnasium building and the later single-storey blocks, plural. How many blocks are there to the east of the Hamilton building?
I would need a plan in front of me to be able to answer that question.
Do you not know that, Mr. Leslie?
I'm trying to visualise the site. I don't have a plan. If I can have a plan in front of me, I can identify that.
Wait a moment, Mr. Leslie. I hadn't anticipated that. Can we look at CD 74, please? Firstly, Mr. Leslie, can we agree how many buildings there are on the site out with the main Hamilton building?
So to the east there is a gymnasium block and a luncheon hall. To the west there is a classroom block and the Gatehouse Lodge.
Well, if we exclude from the sentence the gymnasium block, if we exclude from a consideration the gymnasium building, because you have dealt with it in the former part of the sentence, to which buildings were you referring when you say the later single-storey blocks in the plural?
Looking at this diagram now, then I would say that was referring to the luncheon hall on the eastern side and also the classroom block on the western side.
That's fair. So the position was, as at the date of this letter, planning policies supported the demolition of the gym and the luncheon hall and the classroom block. Is that correct?
That is what's referred to in that paragraph, yes.
And so far as the gatehouse is concerned, that the loss of that could be considered where the benefits of the scheme outweighed the disbenefits of the loss. So that demolition of that was at least a possibility as well at that time, was it not?
At that early stage, we were identifying that the gatehouse, as it says there, would be more contentious. All of that, of course, is subject to the last sentence, which would require the justification in relation to the SHEP tests.
Indeed. But to some extent, you'd already answered that by saying that the policies supported the demolition of the 3 buildings that we've just identified, surely.
If there is a justified case.
Well, that isn't what it said in the first sentence. The first sentence says that the policies support the demolition of these 3 buildings, surely, Mr. Leslie. Is that not a fair reading of it?
I think you have to read the paragraph in the whole. There are a number of sentences there that pick out the individual elements, as you've correctly pointed out to me.
If we go to page 5, do we see that your opinion was that the symmetrical approach is or was persuasive compared to other options tabled?
That is what it says, yes.
Thank you. And you also append us, was it this letter that you had the principles attached to, or is that a separate document? It's a separate document, apologies. 8th of January 2015, you set out the 7 principles that you thought were important or should be observed. Is that so? Or addressed?
Those principles in the email of 8th of January 2015 followed a site visit where design issues were being discussed. So those principles relate specifically to design issues, not necessarily all planning principles that needed to be addressed.
You know, that's fair. Now, I think, I'm not sure if you've been at the inquiry earlier, whether you've been watching us or not, but our position is that we agree with and believe that we have met all of these except for number 4. Are you aware of that evidence, Mr. Leslie?
I am aware that that's the case put forward.
And so far as item 4 is concerned, in light of the detailed evidence that's been given about that, what is your current position?
Again, in taking one consideration in isolation, it's difficult to make comment on that when a full assessment of all issues has been done in the report that was presented to committee on the proposals. These are principles at a pre-application stage that were set out based on discussions on site. These are not principles that have followed from the consideration of all planning information that was submitted with the application.
Well, why is it that you said that development should be pushed back as far as possible? Why was that?
That was based on site observations in terms of the impact on views from the immediate and more distant locations and how development could be accommodated without breaking skyline, etc.
And what do you say about the importance of the setting of the A-listed wall and Belvedere? What do you say about that, Mr. Leslie?
I don't think there was any reference in this email to that particular point.
No, sorry, there isn't. But what's your position about that now? That hopefully you have heard or read our very detailed evidence and research into that issue. What is your position now? Do you accept the merit of what is suggested respecting the setting of the A-listed northern wall and the Belvedere?
I think that's a level of detail in relation to the assessment of the application, which subsequent witness will address in more detail on heritage matters.
Right. So are you not really in a position to address that sort of detail? I
am not an expert on that matter. No.
Right. Well, in principal terms, as head of planning, would you accept that serious consideration has to be given to the setting of A-listed structures?
That is part of our assessment of the proposal, yes.
Now, just continuing with the advice given, could we turn to look at document 383? And this was pre-application advice given by your department. Is that correct?
Correct.
Now, if we go to the last page of the document, headed Potential Height, do we there see that we were advised by your department that on the east wing there could be a development up to about 86 metres in height?
That was provided as general guide in terms of massing, yes.
Yeah, I'm fully aware that this is general guidance and, you know, it doesn't constrain the committee or whatever, but we're just trying to get an understanding for what has happened here. And that the advice was that that should be tiered development, different floors with different heights, both tiered and staggered, so to speak.
That is the option shown in the diagram, yes.
And give or take, Mr. Leslie, is it fair to say that that is very similar indeed to what has been provided in the planning applications that were lodged with you, given the diagrammatic form of these, save for one feature? That block has been moved forward to preserve the setting of the wall and the Belvedere. Save for that, it is very similar indeed, is it not?
I think the architects had full regard to the advice that was given on that particular feature.
And can we agree not only did they have regard to it, but actually what has been proposed is very similar indeed to what is shown here?
In a general sense, yes.
That's very fair. Thank you very much. And if we look, please, at the first document, or second page, which is the demolition plan, can we see there that there is an acceptance that all four of the outlying buildings may be demolished? There's no embargo in demolition, provided, of course, there are sufficient justifications given.
I think that's consistent with my answer to your previous question about the status of each of these four buildings.
Absolutely. I completely agree, but my point is this: we've been told this not just once, but on a number of occasions as to the position about demolition. That would be fair, wouldn't it?
Yes.
And this document goes further because it will actually support demolition of the luncheon building and the single-storey classroom, for reasons which we'll hear about later from other witnesses.
Yes, in the justification of the proposals when all assessment issues have been balanced.
And do we also see within this document that there is an acceptance of the possibility or suitability for development on the western playground as a matter of principle? And we'll come to look at location in a minute, but there's no suggestion of no development on the western playground at all. It's quite the opposite, isn't it? Sorry, from the very last page of this document.
The last page of the document referring to potential height.
Yes, it shows the height. To be fair, it's not a very generous height, it has to be said, but it's nevertheless accepting the principle of development on the western side, on the western playground, at a location not very distant from the Hamilton building.
It's accepting the potential of development on the footprint of the classroom block and an area to the front of that.
Well, actually, it's about twice the footprint of the classroom block, is it not?
It is about twice the footprint, yes.
And if we go to the front page of the document, we see that reflected in the text. Luncheon hall and classroom block is likely to be acceptable. That's the demolition of them. And demolition of the gymnasium building will be justified if the benefits outweigh the loss. Have you yourself, Mr. Leslie, been inside the gymnasium building?
I've not been inside it. I've been on site and seen it from the outside.
Can I then take us to the Council's position statement, CD 161?
Sorry, Mr. Steele, was that CD 6161?
Sorry, is that not what I said? 161?
No, you said 6161, and we don't yet have 61,000 documents. Though it does feel like that at
We
times.
might come to them very soon. But it's 161, I apologise. Council is taking stock of the position in January 2017, Mr. Leslie. Is this your document? I don't see an author on it.
I don't recall which member of staff prepared this, but it will be a document sourced in the planning service, I think.
So it's a document that you've seen, doubtless.
I have seen before, yes.
Right. So can we just see where the Council was in 2017? We've helpfully got the timeline set out in box 2 and confirmation about the photographic museum not coming to fruition and the likes. At 5.2, the Hill Adamson Trust concluded that the project was not viable. That's the photographic centre. Is that correct? That was after 9 years. Is that so?
As stated in this report, yes.
And I'm not going into the competition, but we see there listed what happened at the competition, the number of entrants, And do we see at 6.3 that there was dialogue and planning services were involved in that? And arising out of that, my clients secured the site. Is that so?
That paragraph appears to be accurate.
And after, if we turn to page 6 of 7, that summarises the position in relation to the first application, does it not, at the end of paragraph 9.2. Put simply, too much building is being proposed for this highly sensitive site. That was the Council's position in relation to Scheme 1. Is that correct?
Yes, that was stated at the Development Management Subcommittee.
And do you accept, as a matter of fact, that Scheme 2 had less building that was being proposed for the highly sensitive site?
It can be less, but still too much.
Well, I realise that, Mr Leslie, and I know you want to get that point in, but for my purposes, the question is this. Do you accept that there was less building than originally proposed?
The proposal was a reduction in scale, yes.
How much was the reduction in scale, do you know?
I believe the number of bedrooms reduced by 20.
And what about height, scale and massing? How much did that reduce, do you know?
Not offhand. I would have to refer to the assessment reports, which put that level of detail.
Well, let me just, if I may, just ask this high-level question. Given that we had gone some way to meeting your concerns in the first application, can you explain why there were more reasons for refusal put forward by your department for the second application? I'm not going to go into the detail of it with you, because that will be for other witnesses, but just in general terms, do you see that that seems a little difficult to understand? So can you just explain why that was?
The first point I would have to make is that each proposal is assessed on its own merits. So it wasn't a case of comparing the second proposal to the first and deciding how many reasons of refusal to have. The reasons of refusal come from the assessment of the application and the relevant policies and guidance. So a second assessment of looking afresh at a new proposal may come up with a different set of reasons for refusal.
Well, I understand that that's the obvious answer, Mr Leslie, but let's just try and look at this logically. We have Scheme A, which you tell us is too big. We go away and we come in with a scheme that is either smaller or significantly smaller, depending on your point of view. It may still be too big. I accept that. But logically, it doesn't seem right, does it, that there would be more reasons for refusal for a smaller scheme than the bigger one, given all the other aspects were the same in relation to the main building and the design was exactly the same. Would you agree that on the face of it, that seems a little odd?
No, I don't agree, because I'm saying it's an assessment of a separate application. I'm not making that comparison.
So there's nothing illogical about that at all. Is that the position?
I find it perfectly logical that an assessment of a new application may reach a different set of reasons for refusal.
Well, that wasn't the point. It's not a different set. It is a larger number. More opposition was put to us than for the larger scheme, Mr Leslie. Does it not strike you as curious?
No, again, I'm referring back to this was a new application assessed on its own merits. The reasons for refusal derive from that assessment.
Now, if we can just look at page 6 of 7 and 7 of 7 of this report, where you deal with the Trust's proposal. And you or your department say this: however, the Trust does not have an agreement with the Council relating to the use of the school, and the Council remains under contract with DHP, so there is no prospect of these proposals going forward at the time being. What do you mean by the use of the words "no prospect of these proposals going forward"?
That paragraph is referring to the fact that planning permission doesn't entitle a developer to progress without consent from the property owner. That's out with the planning process.
And so far as you are aware, noting, of course, that you're head of planning, is there any agreement of any description in place with the Trust?
I'm not aware of the Council's relationship to the Trust.
But you are aware that there's a legally binding contract with DHP, are you not?
I'm aware of that, yes.
And it is for that reason you say there's no prospect of the Trust proposals going forward?
That would be my understanding, yes.
So, to put it another way, we simply cannot be certain that the Trust proposals can ever be implemented. Would that be correct?
From my perspective, the Planning Authority granting planning permission does not have a relationship to the implementation of that planning permission in terms of property consents, in terms of property ownership consents.
Yeah. We cannot be certain, can we, that the Trust will be able to implement any consent, can we?
I think you could ask me of that of any applicant for planning permission. It's not a matter that I can comment on from my statutory responsibility.
But Mr Leslie, I wonder this, that you know that there's a legally binding agreement between the Council and my clients which gives them utter control over the site. It must surely follow that the Trust can have no interest in the site as things stand, as you say here.
I've never seen the detail of that contract, so I'm not able to clarify whether you're saying is correct or not. There's a general conclusion drawn in this report that is based on the understanding at that time.
And that still remains the legal position, doesn't it?
Again, you're asking me to comment on the contract. I don't know if there has been any further change to that contract.
Right. So if you're intending to have a break, if so, that would be a useful point to have it. It's nearly 3:30.
Thanks, Mr Steele. That sounds fine. Let's break until 3:35. Thanks.
Leslie, thank you. Mr Leslie, you tell us in your precognition at pages 2 and 3 about the workshops, and I don't intend to ask you details about that, just some 2 or 3 general questions. The workshops were attended by representatives of HES, is that correct? Historic Scotland in Old Money.
Yes, I think they were certainly present in some, if not all, of the workshops.
And I think you attended them all, or the majority?
I attended 4 of the 5 of the original workshops.
And they were chaired as a matter of agreement between the parties by a well-known and respected local solicitor, is that correct?
That is correct, yes.
And you'll be aware that he prepared a report afterwards about the workshops.
Yes, which was subsequently discussed in a review meeting with the Council's Chief Executive.
So you are aware of that report?
I don't recall actually seeing the report. I recall attending a meeting where the report was discussed.
Well, if somebody in relation to Historic Environment Scotland, or HS as they were at that time, had said this: conservation and preservation had become prevention, would that be consistent or inconsistent with what you witnessed at the workshops which you attended?
Sorry, Mr Steele, which document are we looking at?
We're not looking at a document, are we, Mr Steele?
I didn't put a document. Sir, with respect to my friend, the constant interruptions are really not very helpful. I didn't put a document. Thank you.
proceed any further, I think I'm right in saying that I wasn't present at the first pre-inquiry meeting, but I understand that there was some discussion at the first pre-inquiry meeting in relation to the first scheme, Mr. Ron may recollect this, about this very document, which I understand is not before the inquiry. I may be wrong about this, but I'm advised that we think at least that's the document that's been referred to. And if that's the case, first of all, can that be confirmed? Are we talking about the same document that I'm referring to?
I'm not referring to any document. My question was
So
simply...
you're referring to a report, I think.
I asked, firstly, if the witness was aware of a report, sir, but he has said he doesn't know about it, or hasn't read it, I think was his position, and he's nodding in the affirmative. Therefore, I have not put the detail of the report to him. What I then went on to say is if somebody had the impression, which I put to him from that meeting, would that be consistent or inconsistent with Mr. Leslie's understanding of what happened?
What you said, I think, is if someone said, then you put some words to the witness. So are you putting a specific quote and asking if the witness recalls those words being used at a meeting, which may or may not be referred to in this document that you have before you?
I can try it again, sir. Apologies if it wasn't clear enough. If somebody had the impression... If somebody had the impression that conservation and preservation had become prevention, would that be consistent or inconsistent with your understanding, Mr. Leslie, as to what happened at the relevant workshops which you attended?
Regardless of where that quote may have come from, it's not my recollection of the workshops that a word prevention would typically identify the discussion. The workshops were conducted in a way of being constructive.
It's very helpful, Mr. Lett. Thank you. Now, next issue. Did you, I know you didn't write or weren't the author of the report for the second application, but you did edit the report. Did you attend that committee meeting for the second application?
I did not attend the Development Management Subcommittee in 2017.
Right. So if I want to ask questions about that committee meeting, it would be for another witness. Would that be fair?
Yes, the case officers attended that meeting.
Right, that's helpful. Thank you. That makes progress. Now, the council witnesses who were most closely involved with the workshops, apart from yourself, obviously, were Mr. Girvan and Mr. Nicholson. Is that correct?
Yes, as managers at the time of those applications, they were, yes.
And are they planners, or the architects, or landscape architects, or what are they?
Both are dual qualified as architects and planners.
So they were architects as well as planners who would have some particular interest, I dare say, in these schemes and the architectural aspects. Would that be correct?
Yes, we operate very much a team system within the planning service, and their expertise would be alongside that of other experts.
And as architects, Mr. Leslie, were Mr. Girvan and Mr. Nicholson in any way supportive of the design concept, the materials and the likes?
I think in the first subcommittee meeting, Mr. Given presented the details of the application to elected members, and I can recall him commenting positively in terms of aspects of the architecture. I wasn't present at the second meeting. I don't recall whether these points... I don't think Mr. Given was present in the second meeting.
No, I don't think he was. But in relation to the first meeting, I mean, to cut to the chase, Mr. Girvan was actually quite supportive of certain aspects of the proposal, was he not?
I think we presented to elected members a very balanced assessment of the proposals. There were positives, there were negatives.
Well, that's obviously the case with every proposal, Mr Leslie. Even I understand that. But Mr Girvan was actually quite supportive of several aspects of the proposal, was he not?
He was referring to the aspect of the assessment of the report, which is submitted as inquiry documents. So he was presenting to members the detail of what was in that assessment.
Well, Mr Leslie, I detect you're being a bit defensive here, and apologies if I've got that wrong, but can I just repeat the question? Is not the truth of the matter Mr Girvan was actually quite supportive of the proposal?
I think I'm answering the question on the basis of the combined assessment of the application. It's difficult for me to comment about the personal assessment by an individual officer. As I said, we work as a team, and there are many different specialist views input to the assessment of the proposal.
And in relation to the first scheme, and you were responsible for the report directly, and you attended the committee meeting, was there any thought at any stage of actually recommending approval or even a neutral recommendation?
I think the relevance is the conclusion which we reached once we had assessed all material matters, and that's reflected in the recommendation of the report.
I understand that, Mr Leslie, but was there any consideration given in relation to the first scheme of actually recommending either approval or a neutral recommendation, i.e. not approval or rejection?
Well, firstly, it is not our practice to present to elected members a neutral report. I think we have a duty as professional planning advisors to the Council to reach a considered position. Our reports highlight the positives and negatives. It's for elected members to then assess our recommendation against whether we've given the correct balance. So I wouldn't agree that we would have ever thought about putting forward a neutral position. In terms of an approved position, it's not something that we reach in terms of our assessment discussions. It's we assess all of the proposals together, we pull them together, and on balance we are then reaching a recommendation.
Well, I understand all of that, Mr Leslie, but my question really is a very simple one. Was consideration given at that stage to a recommendation for approval?
I don't recall that such a decision or such a consideration, rather, was reached during that discussion.
Can we agree, and I'll go through the detail subsequently, that the report at certain passages is really quite positive in favour of the proposal?
I've already said the report presents a balance in terms of positives and negatives, so some parts of the report are positive.
Can we agree that the recommendation for a refusal in relation to the first scheme was a balanced one, firstly, and secondly, a marginal one?
I agree that it was a balanced assessment that led to that recommendation. I don't recognise the use of the word marginal.
Well, it was a pretty close call, was it not, Mr Leslie? Had consideration not been given to actually recommending approval?
No, I can't agree with that.
Is there any reason Mr Girvan is not a witness at this inquiry? That you know of, that you can tell us?
He doesn't currently have any responsibility for development management.
Yes, but as the official who was very, very closely involved with it at the time, there would be a certain logic to leading him as a witness now, would there not?
I think other witnesses that the Council is putting forward can adequately address the points that you're raising.
I see. There's nothing more to it than that, then?
No.
So can I just try and summarise the position, Mr Leslie? My clients won this competition in the face of considerable opposition. Is that correct, factually?
Again, I wasn't involved in the competition, so the use of the words considerable opposition isn't something I can judge.
There were 54, more than 50 other competitors. You must know that.
That's a volume issue rather than whether or not they were suitable competitors to the winning entry.
Right. So is it too difficult to accept they won the competition in the face of considerable opposition numerically?
I accept there were a considerable number of other bids.
And at that time, it was said that there was policy support for the hotel?
The local development plan accepts the principle of a hotel.
Thank you. It actually doesn't just accept it, it actually supports it, does it not?
The policy does.
Support it?
Yes.
It's not just an acceptance, it's positive support, is it not?
It supports it subject to the consideration of all other material considerations.
At that time, we showed block development or development in block form of some height, both east and west of the main Hamilton building, did we not?
At the time of the competition?
At the time we won the competition.
I believe that's the case, yes.
Thank you. And throughout the process, we have always shown development on both sides of the main Hamilton building throughout the design process.
That is the way the workshop series started. A number of options were then explored.
And the Council have accepted from the outset the possibility, for reasons previously explored, of all non-original buildings, these being 4 in number, being demolished.
Subject to there being a net benefit from that.
Yeah. At no stage have we ever been told by City of Edinburgh Council that there should not be development on either the east or west platforms, have we?
But qualified in terms of scale and other factors.
Indeed. Yeah. But as a matter of principle, we have never been told by the City of Edinburgh Council that there cannot be development on either the east or west platforms. That's accurate, isn't it?
That is what the development principles showed, yes.
The second scheme is a reduction in height, scale and mass from the first scheme. Is that accurate?
Yes.
And finally, in your own words, there is no prospect of the Royal High School Preservation Trust proposals going forward.
Again, I've referred to that as a contractual matter. Based
of course,
on
it's
my
not a
little
contractual
understanding
matter,
of that.
your understanding of the issue. Thank you, Mr. Leslie. I have no further questions. Thank you for your assistance.
Just one question from me, Mr. Leslie. At paragraph 2.4 of your precognition, you say that despite extending the workshop series, you didn't have a consensus on key planning issues when reporting back to the Chief Executive. When you say no consensus, is that between the Council and the developer, or was that referring to the views of other parties such as HES also?
I'm referring to all participants in the workshop, which did include other parties.
And is it possible to say whether there was consensus between the parties other than the developer, or was there a range of views amongst the parties at that stage?
There were many issues we didn't address in the workshop series, so I do recall that some of the parties wanted to explore issues that we'd not had a chance to discuss between parties, so it would be difficult to say that there was consensus given that there were issues that were not explored. So.
Okay, thanks for that. I'm assuming no questions of clarification from any of the other parties. No. Mr. Thompson.
Thanks, sir. Mr. Leslie, just a couple of points. You were taken to CD 383, which was the Statement of Pre-Application Planning Advice. massing analysis. It looks like that. I think it consists of a page of text with the photograph of the Royal High School on the front, and then I think 4 diagrams behind. Could you tell us the relationship between the text on the front and the diagrams that follow?
First of all, this statement was produced as a way of seeking to progress discussions on an alternative scheme. So it pulled together a set of considerations which we thought would be helpful to the applicant's design team. The text on the front, on the first page, does seek to explain the detail of the diagrams which then follow in the subsequent 4 pages.
Would it be safe to use either without the other?
They have to be read together in the same way that a development plan policy should be read words and proposals map.
Thank you. And then I wonder if you could have, please, CD 378 Appendix 6, which is the famous email with the 7 principles. And it was put to you by my learned friend that the appellant's position was that it was only one of those 7 principles that wasn't met, and that was the one relating to whether a building to the west should be pushed back or not. What's the Council's position on whether either Scheme 1 or Scheme 2 meets the other 6 principles?
Well, first of all, this is pre-application advice, so it's not given an assessment of all information submitted. That is within the report to the Development Management Subcommittee. And the Development Management Subcommittee report goes through each of these points in detail. So I think if we picked a number of these, we would see that with the full information provided, we did not accept that principle had been met in full. And that's part of the assessment in the report to committee.
Thank you very much, Mr. Leslie. Thank you, Saz.
Thank you, Mr. Thompson. Thank you, Mr. Leslie. We're moving on now to hear the Council's second witness, who is Julie Waldron. Now, we've got her pencilled in indicatively for tomorrow morning on the programme that was issued, but I think we shouldn't read that as set in stone, and that we should continue to move forward. We've got an hour left or thereabouts for this afternoon. Mr. Thompson, a short break to get Ms. Waldron in place.
Yes, sir. She has certain practical difficulties which might have made it more desirable for her to start in the morning, but I'm in your hands.
Are they... See, I don't want to know what the difficulties are, but is there any good reason, for example, not to take her evidence in chief this afternoon?
Perhaps if you could allow me 5 minutes just to check on the position. We'd anticipated this problem not arising, frankly, because we thought that Mr. Leslie might last until 4:30.
Clearly the fault is mine for being too brief.
No. Heaven forbid again.
Okay. Can you check
yes,
and
I'll
let us
do
know then, Mr. Thompson? Yeah.
The easiest
thing
to do.
Let's do that.
So from my point of view, I wouldn't make any meaningful progress with cross-examination this afternoon.
Okay.
It then means that the witness can't speak to people. I would have thought certainly across tomorrow.
Okay. Evidence in chief then, Mr. Thompson. Thanks.
Now, good afternoon. You're Julie Waldron. I think your evidence to the inquiry consists of a precognition, a rebuttal's precognition, and an inquiry report, which is CEC 8. I'm going to ask you to read from your precognition, mindful of the desire to save time. It's been agreed that you won't read all of it, and I think you have a copy which you have already effectively redacted, so I would ask you to read it and to indicate when you get to a passage that you're going to miss out where you're going next. So with that in mind, could I ask you to start, please, at paragraph 1.21.
Hello. My name is Julie Waldron. I am the landscape planner who considered the applications in relation to landscape context, landscape design and aspects of the environmental statement. Moving on to number 3, the unique character of the site. The first issue I'm going to examine is character. There is a requirement under the Section 64 of the Planning, Listed Building and Conservation Areas Scotland Act 1997 that in a conservation area, special attention shall be paid to the desirability of preserving or enhancing the character or appearance of that area. Town and Country Planning Scotland Act 1997 further requires that the determination of an application for planning permission shall be made in accordance with the development plan, unless material considerations indicate otherwise, Section 25 and 37. There are many instances where the term character is used in the local development plan. Therefore, it is important to understand the character of the site and the character of its context. One definition of character is contained in the statement. Landscape results from the interplay of the physical, natural, cultural components of our surroundings. Different combinations of these elements and their spatial distribution creates the distinctive character of landscapes in different places, allowing different landscapes to be mapped, analysed and described. Townscape character is a subset of landscape character. It is important to distinguish the characteristics of a site and its context in order to make a judgment about which characteristics should be protected, altered or improved. In some instances, developments can cause acceptable changes to character and improve the characteristics of a site. However, in this case, certain characteristics of the present today are unique and highly sensitive and are the key to the special qualities of the site's sense of place. My inquiry report outlines the baseline characteristics of the site and its context. However, it is important to highlight 5 of these characteristics. The special characteristics of the Hamilton building are examined in my colleague Mr. McMeekan's inquiry report. I note that 4 of the characteristics concur with the observations of 4 of my characteristics, I should have said, concur with the observation in John Lowry's topic paper, and that the composition of monuments is also highlighted in James Welsh's topic paper. The characteristics. Carlton Hill is a crag and tail landform and part of Arthur's Seat's complex. It is a designed and shaped landscape, the careful location of the Hamilton building on a man-made terrace on the side of an important city hill, with the knowledge that the National Monument was planned for the upper area, in effect linking the school building to the landscape and the monuments. The unique composition and spatial pattern. The pattern of the monuments and natural features come together in a unique composition laid out to picturesque principles. The visual illusion of a monumental building created by the careful placement of the Hamilton building within its landscape setting. From certain views, the building looks larger than it really is. The cultural connections of the stories that surround the meaning of the different monuments and their relationship to each other, and how 4 of the monuments have been inspired by Greek architecture. In particular, there's a relationship between the Hamilton building and the National Monument. This contributes to the Athens of the North narrative. The relationship of the Hamilton building within a composition is mentioned in the 2015 Design and Access Statement Landscape Appendix. But throughout the character assessment, this characteristic is not considered a key characteristic. It is my opinion that this is one of the key, unique characteristics of this site. By considering this characteristic less important, the impacts of the proposals can be underreported. This is shown in Roger Maskell's inquiry report, which criticises HES for looking for breathing space around the building. Apart from space being a key to the setting of the Hamilton building, The building is part of a composition, and every monument on the hill has breathing space around it. Instead, there would be the introduction of another characteristic: large buildings on a street of both modern and traditional buildings. This is not unusual in Scotland. However, in this part of Edinburgh, the buildings have intentional space around them and are carefully located in a landscape setting along a road. The creation of this new characteristic would damage the existing unique characteristics. So, damage to the character. In the ES assessed the impacts on the characteristics of the site, Carlton Hill, the Garden and Designs Landscape, Special Landscape Area, the Newtown Conservation Area and the World Heritage Site. It is important that the proposed architectural design solution would not damage important characteristics of these areas. I find the outcome would be significant and adverse for all of these areas, and my finding concurs with James Welch's. Now moving on to paragraph 4.3. In the assessment of Carlton Hill in the 2015 ES, the appellants identify that there are isolated monuments at the top of the hill and public buildings with space around them, noting that the Royal High School is clearly part of an urban composition, but miss out the cultural connections between the monuments. In the 2017 ES, the baseline changes, and the description, space around the buildings, in the 2015 ES, has been removed. As this characteristic is associated with being part of the composition, it is my opinion that the loss of this characteristic is adverse. Mark van Greken's inquiry report finds the development in scale with other development along the road, putting more emphasis on the relationship of buildings along the road than the building being part of a composition on a hillside. I disagree with this opinion because buildings along a street is not a unique characteristic. So moving on quickly to 4.7. In summary, change to unique characteristics of this site and its context are key to understanding acceptability. I consider there would be irreversible damage to these unique characteristics and the introduction of a less valuable characteristic. Appearance of the site in views. As mentioned above, there is a requirement under Section 64 of the LBCA that in a conservation area, special attention shall be paid to the desirability of preserving and enhancing the character or appearance of that area. And the 1997 Act requires the determination of an application shall be made in accordance with the development plan, unless material considerations indicate otherwise. Policies DES 1, DES 4 of the LDP reference appearance and views. Effect on appearance and views are tested through the ES in the visual assessment. This looks at visual amenity, which is the overall pleasantness of the views, and the nature of views. These are more objective observations, for example, the extent of skyline, aspects of visual scale or vertical emphasis, and key focal points. These observations establish the baseline conditions. Interrelationships with the cultural heritage aspect of the views need also to be considered. The visual baseline provides the description on which the ES assessors form their judgments. Now moving on to 5.9. There are 2 nighttime visualizations taken for each proposal. The effects on views rely heavily on a lighting strategy that cannot be secured in the long term, as it requires special interior design of the rooms, which cannot be controlled. The dappled background lighting noted in Professor Travenor's report could be altered. The photomontages submitted are helpful in appreciating the size, scale and context of the development. They are designed to be viewed in the field with an understanding of their limitations. 6. Damage to views. Moving to 6.2. In both the visual assessments, there are significant adverse effects recorded for 4 views. This aligns with my opinion and Mark van Greken's inquiry report. 3 of these views are local views and support my opinion that locally the buildings will create a strong adverse visual effect. These are viewpoint 35, 32 and 21. This is because the height and mass blocks views across the Hamilton building and over to the townscape and alters the picturesque and historically significant composition of the Hamilton building with Carlton Hill as backdrop. The fourth view acknowledged by the applicant to be adversely affected is viewpoint 19C from Canongate Parish Church. In this relatively local view, the proposed development interrupts the view of the distinctive ridgeline of Carlton Hill and compromises the relationship of the Nelson Monument to the hill, again damaging the picturesque and historically significant composition of the Hamilton Building with Carlton Hill. The effect of the sequence of views from Regent Road, view 04 and 27 moving eastwards, is disputed. The effect on viewpoint 4 in the 2015 ES is noticed as adverse by the applicant. I agree with this, and it aligns with Inquiry Report APP 44. In the 2017 ES, the appellants changed the decision to beneficial. And just a quick note, I know Mr Van Greeken, when he was being cross-examined, moved his to neutral. While the development is different, slightly set back and slightly lower, its height and mass still introduce a new, visually powerful focal point in the view. The introduction of the new building disrupts the sequence of views created to reveal the Hamilton Building. Moving to 6.7. When local people and tourists walk along the pavement today, the visual effect of the Hamilton Building is dominant. The new views, the new proposals, by virtue of their scale, mass and height, would overpower the Hamilton Building, so it would no longer be the case. Views to existing features on Carlton Hill would also be blocked, damaging a unique visual experience. Moving to 6.9. More distant views can be seen from within the Royal Park. Viewpoint 08B, north end of Radical Road, is one such view. This is assessed as significant view and beneficial, and relies on the bedroom wings receding into the hillside. I covered before the risks with photomontages in one of the parts I actually didn't read, and my opinion is that overall this will be an adverse effect. This aligns with Mark Van Greeken's inquiry report, with notes he takes the precautionary approach and disagrees with the ES assessments. Other distant views are not considered significant by the applicant in the ES. However, I consider views 9, 10, 11, that's views from Queen's Drive, Arthur's Seat and St Anthony's Chapel, to be significant and adverse. This is because in certain conditions, the development will be a highly noticeable component of the view and detract from the Hamilton Building's landscape setting. Moving on to 7. Setting. Section 59 of the LBCA states that the planning authority or the Scottish ministers, as the case may be, shall have special regard to the desirability of preserving the building or its setting, or any features of special architectural or historic interest, which it possesses. And the 1997 Act requires that the determination of an application shall be made in accordance with the development plan, unless material considerations indicate otherwise. LDP policy ENV3 states that the development will not be permitted if detrimental to the setting of the listed building. The meaning of setting is laid out in the Managing Change in the Historic Environment Setting Guidance. It explains the need to assimilate pieces of information into the assessment process. This includes the current townscape or landscape context and views to and from the asset. In the 2015 ES examines setting in the historical chapter, and Hannah Tweedy inquiry report explains that the assessment was informed by findings in the heritage statement. Now, I just need to stop here briefly. I made a mistake in my report, and I've rewritten the paragraph. So for ease of reference, we do have copies of the new paragraph.
If that's appropriate, I have copies that can be distributed now so that Julie Waldron can read her corrected version of paragraph 7.3.
Sorry, I'm a little confused. You said you were correcting the paragraph in the report.
Sorry.
But is it the precognition?
It's the precognition, okay. And there's a corresponding paragraph in the report which the precognition was written from.
Yes. Could we do that? No objection to that, have you, Mr. Steele?
No, sir. It'll save time. But which paragraph is it in the report? Because that had confused me.
It's 9.2. I have it in my new 9.2. No, sorry, 9.2 in my report and 7.3 in the precognition. So I'm now reading paragraph 7.3 from my precognition that had a mistake in it, and as you read it out, it will make sense. Paragraph 7.
Can I just a second? Which pages do you say is the error in your main report?
Well, it's at paragraph 9.2.
Well, I'm sure I'm making a mistake here, but the paragraph 9.2 I'm looking at in the report is one sentence long, starting this analysis was taken out and so on. I'm not sure that
No, it is correct, actually, because the analysis was not taken out. It'll make sense. The analysis I thought was taken out was not taken out. So this will make sense when I read the report, when I read the paragraph. The 2015 ES examines setting in the historic chapter, and Hannah Tweedy's inquiry reports explain that the assessment was informed by findings in the heritage statement. There is a description in the heritage statement of the landscape characteristics which was not accurately reported in my original precognition. The heritage statement says the open character of the landscape provides the setting for the buildings and monuments, many of them positioned to be prominent on the skyline of the city and as an assembly when seen together. And that's in CD 26, Volume 13, Part 2, J3, 3.8. Also, in the 2015 Design and Access Statement, Appendix C, which is CD 045, Paragraph 3, there is a diagram indicating a zone of monuments on the hill that indicates the Hamilton Building. I note an error in my report at paragraph 9.2, where I state it was missing in the 2017 application. It is not missing in the DAS documents. It is on page 7, the current site analysis of the Public Realm and Landscape Set Statement, CD 192, and also on page 8 in the diagram that states Hamilton Building sits within the composition of Carlton Hill monuments when viewed from the city. This information on the composition of monuments and buildings within the landscape setting has not been fully described in the settings assessment's baseline. This results in an underreporting of the impacts. So moving on to 7.5. Also, the ES assessor...
Sorry. Just perhaps before you do that, could we just look at paragraph 9.2 in your inquiry report, just so that we can complete any corrections that need to be made?
And are we deleting what's at 9.2 and substituting something, or just deleting it? Or?
That's what we're about to find out.
I'd expected you might know.
Apologies. The mistake made was that it was not deleted, and a landscape capacity study was added in. The mistake made was I thought one had been replaced with the other for about 5 seconds. Unfortunately, it was when I wrote the report. But the landscape capacity study was added in to what was already a study by Chris Rankin showing the character of the landscape. It moved from one part of the DAS to a different part. So the DAS that originally changed it was a Hoskins DAS with the yellow covers, and it moved into a separate document. But what Mr. Rankin produced was all the information from 2015 plus a landscape capacity study.
So what do we want in place of 9.2? All of that?
Sorry. What we need to replace at 9.2, we could say this analysis was also included in the 2017 Design and Access Statement, and a landscape capacity study was introduced.
I wonder, and I'm especially thinking about when we are summarising this evidence in the weeks and months to come, could updated electronic versions of the precognition and inquiry statement be forwarded to our office?
Of course, so, yes.
Perfect.
Sir, whilst we're confessing to things, could I take this opportunity to suggest that I reissue Mr Leventhal's precognition with numbered paragraphs and numbered pages?
That would be useful.
Okay. Okay, right. Moving on to, just get that in the right position. Moving on to 7.5. Also, the ES assessor rated the magnitude as low or negligible. This creates a series of results which indicate that there is no significant effect on the asset. On several of these assets, I do not accept this opinion. Dougal-Stewart's monument, Nelson's monument and the National Monument are all part of the composition of monuments on the hillside and all have a landscape setting. They are visible from a wide area from the south. Both the 2015 and 2017 proposals reduce the landscape setting and depth of the landscape beneath the monuments in varying amounts. Certain views at certain times, the new development will create an eye-catching focal point that will distract from this composition. This would be a significant adverse effect on the setting of these monuments. With regard to the Hamilton building, the historic environment chapter of the 2017 ES was expanded from the 2015 application, but the conclusions are the same. It states there would be no significant effect on the setting of the Hamilton building or the historic assets in the wider study area. I disagree with this conclusion. It is stated that the proposed development would result in a slight change to the setting of the former high school. This is a surprising conclusion. Roger Maskell's inquiry report opposes this view and states clearly there will be significant changes to the setting, and goes on to say, but that does not automatically equate to significant harm. I agree. However, in this case, due to the sensitivity of the setting, I consider that it does result in significant harm. And that's where we're going to finish.
So, subject to the substitution of paragraph 7.3 that we've already looked at, and subject to producing a revised paragraph 9.2 of the report along the lines you've indicated today, does that constitute your evidence to the inquiry?
Yes.
Thank you very much. Makes sense.
Thank you, Mr. Thompson. I guess that's it for this evening. Anything that we need to consider before we close? Nope. Okay, well, just a reminder, it's 10 o'clock tomorrow morning. We'll see you all then.